you. We will hear argument first this morning in case 24-316, Kennedy versus Braidwood Management. Mr. Mupan.
Mr. Chief Justice, and may it please the court. Task force members are inferior officers because they are subject to ample supervision by the Secretary in issuing recommendations that bind the public. Most importantly, the Secretary can remove task force members at will. His power to remove them flows from his power to appoint them, acting through the Director's authorities. And this court has repeatedly recognized that at-will removal power is a powerful tool for control. Moreover, the Secretary can review task force recommendations and prevent them from taking effect. During the minimum interval period, he can direct the task force to rescind a recommendation, and he can replace task force members as needed to ensure that happens. In addition, he can require the task force to obtain his pre-approval before they issue any recommendation at all. Given these collective powers of supervision, the task force cannot issue final recommendations that bind the public unless the Secretary permits them to do so. Respondents' contrary argument rests entirely on the statutory language providing that the task force shall be independent and, to the extent practicable, not subject to political pressure. But as this court's cases make clear, that language does not create a restriction on removing the task force members, and it does not impose a bar on reviewing their recommendations. It certainly does not do so clearly enough to overcome the canon of constitutional avoidance, especially since the language itself contemplates some amount of political involvement. In all events, if that statutory language is the constitutional problem, then the solution is straightforward. This court should hold that the language is unenforceable and severable. It is neither necessary nor appropriate to hold instead that task force members must be appointed by the President and confirmed by the Senate. I welcome this court's questions.
Before we get to the constitutional problems, what's the statutory authority to appoint the task force?
So there are two sources of authority, Your Honor. The first is that under the Reorganization Act, the Secretary has the power to exercise all functions and duties of the Director. And the Director, under 299, has the authority to convene the task force.
Isn't that an odd delegation? Normally, it would be the superior or the principal officer who would have the authority, who would delegate it to subordinates.
Well, it's not just a delegation, Your Honor. The Reorganization Act was in place when 299 was enacted, and so when Congress passed 299 and said that the Director could convene the task force, that meant that the Secretary could convene the task force.
So the word, you're using the word convene?
Yes, Your Honor.
Well, I think that normally connotes just calling a meeting or something. The court was convened this morning. The chief didn't appoint any of us.
So I agree, Your Honor, that convene doesn't necessarily connote appointment, but there's no other language in the statute that specifies who will appoint these members. And in light of that, convene is most naturally read to mean convene and select the people who will serve on the board. And that's clearly true before the ACA. Before the ACA was enacted, it's clear that the Secretary and the Director had the power to convene to appoint these individuals.
But appointment would not be an issue if they had no authority to require anything of others. It's just advisory.
Well, not as a constitutional matter, but as a statutory matter. And I took your question to be, where is the statutory authority to do this? Before the ACA, it had to be the case that the Secretary and the Director had the authority. It would not be constitutional for the President to select and the Senate to confirm these individuals before the ACA, because before the ACA, everyone agrees they weren't officers, and the Senate has no constitutional power to have any role in the selection of a non-officer. So the only way to construe the statute before the ACA is that the Secretary and the Director had the ability, and nothing about the ACA changed that.
Can you give me an example of another body that's selected this way? Just with using the operative term convene, and that had been, and that the authority comes from through a subordinate to the principal.
So not off the top of my head, Your Honor, but again, as a statutory matter, if we're just talking about how the statute should be construed, there is no other provision anywhere in the code that says who will pick these people. So the most natural way of reading a provision that says that he shall convene the task force is to also select the people who will serve on the task force.
Don't
This
you
is-
rely, I'm sorry.
What the task force does is fairly technical, medically and scientifically. I mean, is the secretary really supposed to be in the position of going down the line and saying, yeah, I mean, I know you think we should use this particular thing with this atomic structure and all that kind of stuff, but I've got a different view on that. Is that a pertinent consideration in deciding whether they're adequately supervised?
Well, Your Honor, the Secretary clearly has the authority to do so. Whether he chooses to exercise that authority or whether he instead chooses to defer to the expert judgment of the task force isn't relevant to the constitutional question. As a constitutional matter and as a statutory matter, he has the authority to review their recommendations. And that's the critical point for here. In addition, though, to take a step back, it's not just that he has the power to review the recommendations, he also has at-will removal power, which this court has repeatedly said is a critical means of control. So even before you get to the question of if they issue a recommendation that he may or may not disagree with, is he going to get into the technical science of it? His mere ability to have at-will removal power is a powerful means of control, and that's what this court has recognized in cases like Edmund and Free Enterprise Fund.
Mr. Mubhan, on that score, the removal at will argument that the government makes hinges a lot on the assumption that the removal power comes with the appointment power, and that because the Secretary has the power to appoint, he therefore has the power to remove. The Fifth Circuit didn't address the antecedent question whether the Secretary indeed has the power to appoint. What do we do about that? Should we remand the case to assess that in the first instance? Just as Justice Thomas's questions point out, there seems to be some reason to question that.
Well, so I guess what I would say is the following. There is certainly no removal restriction in the statute. So whoever it is who has the ability to...
Whoever it is
Right.
an important question, though, right?
So I take the point, Your Honor, but in terms of the question of is there a removal, at-will removal, there is at-will removal.
I understand that, but you say the Secretary has that at-will removal power. That's a pretty critical premise of your argument, and it's an untested premise, one that the Fifth Circuit hasn't addressed.
So,
and is being really addressed here for the first time, as you point out, and therefore, would you object to a remand for that consideration of that question?
well, we think it is fully briefed here, and we think the court is capable of deciding.
Well, you also cite Cutter and tell us, we're not normally a court, reminding us,
So-
as if we need it, that we're a court of review, not first view.
So I won't object if this court doesn't want to address that question, but we do think the answer is quite clear for the reasons with my colleague, Justice Thomas. I don't think the statute could plausibly be construed to vest the appointment in the president and confirm.
I agree with
confirm
that,
by
but
the
whether it vests it in the director as opposed to the Secretary is an interesting question.
Well, but that's a very easy question, because if you agree with me, it's at least in the director. The Reorganization Act.
I understand you think it's easy. Counsel always thinks it's easy,
Also,
but I'm pretty sure Mr. Mitchell doesn't think it's quite he probably thinks it's easy too, just the other way.
well, to be fair,
And no court's passed on the question. And so again, I ask you, do you have any objection if we were to remand it?
we don't, but to be fair, I don't even hear Mr. Mitchell to disagree with what I'm about to say, which is that the Reorganization Act of 1966 clearly vests the Secretary with all the powers of the director. So if the director has the power, the Secretary has the
And
power.
that includes, doesn't it, subdivision B2, which transfers to the Secretary the power to make such provisions as she shall deem appropriate, authorizing the performance of any of the functions of the director?
That's correct, Your Honor.
And so if they have to convene something and no one else is appointing them, then the director appoints them, right?
That's right, and importantly,
And removes them.
correct. And Mr. Mitchell's point about the Reorganization Act, what he focused on is whether the task force is an advisory board. But that's irrelevant to the question we're talking about right now, because that's a question about whether the task force powers have been vested in the Secretary.
Now, the chief
director,
asked you a question about supervising technical advice. That might be true of even us. We're given law clerks to help us on some of the things we don't know anything about. That's the nature of an agency, isn't it? That they hire experts to help the decision makers come to a conclusion?
Right, that was the essential reasoning in holding a free enterprise fund, in fact, was that you can have bureaucrats but not be ruled by them. So yes, you have bureaucrats who contribute their expertise, but ultimately the final decision power is in a politically accountable head of an agency.
And that word independent could mean that people on the task force have an obligation to give their independent opinion, but that doesn't mean that the secretary has to accept it, correct?
That's exactly right, and I would point this court to how this court has described administrative law judges in Butts versus Economo.
And that's an incredibly strained interpretation of the term independent. Are you independent of the president?
No, Your Honor.
I mean, he is counting on you to exercise a degree of independent judgment. But if somebody's removable at will, that person is not, in any ordinary sense of the term, independent.
Well, with all due respect, Your Honor, in Your Honor's opinion for the court in Collins, this court held that there are many statutes that use the phrase independent to describe an entity that is nevertheless not subject to a removal.
All right, well, maybe that's a little bit unfair, but I mean, maybe I was wrong in Collins. But explain to me, explain to me how somebody can be independent and yet subject to removable on the whim of the president.
Sure, as Justice Sotomayor said, it's independent in the sense that they have both the duty and the power to exercise their own best judgment. That doesn't mean that once they've done so, they're free from accountability. It just means that when they are making the decision, they have an obligation to exercise their best scientific judgment.
Well, let's say they are removable at will, okay? And independent means something. It's like a precatory directive. Still, if the task force rates something A or B, then that's it. And you try to get around, and even if the members are removable at will, the only way you can get around that is through some really jerry-built arguments.
I don't think so, Your Honor. Let me give you the most straightforward of them. Under the statute itself, no recommendation takes effect until the secretary sets the minimum interval period.
Right.
And the minimum interval period is at least 1 year.
Yeah.
So 1 year is more than adequate time for the secretary, if he doesn't agree with the recommendation, to direct the board to rescind it, the force to rescind it, and if the task force doesn't rescind it, to replace them with people who will. That doesn't seem very jerry-built to me. In addition to that, the secretary also has the power to create a pre-approval requirement. Under 300 GG 92, he has rulemaking power to implement this statute, and he can say, before you issue any recommendations, submit it to me for my approval. And if and only if I approve it, can you issue it in the first place? Again, that's not all that jerry-built, and it perfectly serves.
If Congress really wanted these task force members to do the bidding of the secretary, isn't that an incredibly odd way to go about conferring that authority?
No, because critically, we are not saying that Congress wanted the task force to do the secretary's bidding. We agree that the secretary cannot tell the task force to make a given recommendation. If the task force doesn't want to make a recommendation, it doesn't have to make a recommendation. Our point is simply that if the task force does make a recommendation, the secretary can block it. It's, to use an analogy, it's like bicameralism. The Senate can't force the House to pass a bill. But if the Senate doesn't also agree with the bill, it doesn't become a law.
Well, under the argument that you've just made, why can't the secretary demand that a particular recommendation be made using exactly the same authority that you just outlined? What am I missing? The president says, I want you to make this recommendation. And if you don't make this recommendation, I'm going to remove you and replace you with somebody who will make the recommendation.
So he can remove them, but we don't think he has the ability to force them to make the recommendation, because we do think that the phrase independence, and more importantly, the phrase the recommendations made shall be independent in 299B4A6, we do think that that language does prevent that. And that makes perfect sense. If you take a step back and think about the statutory scheme, Congress was, as it often does, balancing competing objectives. On the one hand, it wanted the benefits of an expert body. It wanted recommendations that reflected their best scientific judgment. But on the other hand, it recognized that you need to have political accountability. And so the secretary can block it. And that solves the problem. It means that no final decision can be made that binds the public unless the secretary approves it.
Mr. Mupin, doesn't that make it difficult for you in your inferiority argument? Because what if it's a big priority of the president to have these AIDS prevention drugs available, and the task force says, nope, not going to do it? I mean, doesn't it seem then that that insulates them, especially if, Justice Alito said, well, what if you fire him and say, I'm going to appoint a task force who will approve these as preventative care?
So 2 points about that, Your Honor. The first is I think this court has already resolved that question in Free Enterprise Fund. So in Free Enterprise Fund, this court held that once the PCAOB was made removable at will by the commission, they were inferior officers. Even though it was conceded, there was no statutory authority whatsoever for the commission to force the PCAOB.
So that's enough. Your position, because it was a little bit difficult to tell in your brief, you're saying that's enough. At-will removal is all that's required.
No, that's not what I'm saying, Your Honor. We've said that it's both the at-will removal power plus the powers of supervision we've talked about. But critically, those are powers of supervision to block recommendations. You asked me, well, what about forcing them to make a recommendation? As to forcing them to make a recommendation, our point is you don't need supervision in that respect. Free Enterprise Fund already holds that as long as they're removal at will, the fact that you can't force them to take action does not make them principal.
Can't you force? Go ahead.
The last thing I was going to say, which perhaps Justice Kavanaugh was about to say, is you do still have at-will removal power in that context. And so therefore, you do have some means of ensuring the recommendation gets made. It's just the means is replacing them if they won't do it. But you don't have statutory authority to force them to start, and Free Enterprise Fund already blesses that arrangement.
Well, why is it that in your brief, and again here, you're reluctant to say that the removal power is sufficient?
Well, we just don't think the court needs to go that far. This court has always, in cases like Edmunds and Free Enterprise Fund, taken an incremental approach to how it determines the line between inferior and principal officers. And we think in this case where there's both at-will removal plus abundant means of back-end supervision, that's all this court needs to do. And to be candid, I think there would be harder questions if, for example, you had an officer who had the power to issue very important, very broad-ranging decisions that took immediate effect, couldn't be stopped on the back end, and the only means of supervision was front-end removal. We haven't taken a position one way or the other on that, but I do think that that's a harder question, and that's why we don't think this court needs to go there. But that said, you don't have to go very much further than that on the facts of this case, because here, not only do you have at-will removal, you have the critical difference that the recommendations don't take effect immediately. They don't take effect for at least a year, and within that year period, the secretary has ample time to ensure they never take effect. And so those two alone, we're perfectly comfortable saying that that's sufficient for inferior officers.
Mr. Mupin, can I go back to Justice Gorsuch's questions about at-will removal, because he at least suggested that we may not have at-will removal here. And I guess I'm wondering about the presumptions in our law related to the removability of officers. So do we really need to send it back for resolution of that if the law presumes that where there is no statement regarding this, at-will removal is at play?
So again, Your Honor, I agree. I don't think there's any colorable argument that there's a removal restriction here. The only colorable dispute is whether there's actually appointment authority.
Right, and what does our law say about that situation? I mean, part of the problem here, I think, is that we are talking about a statute that doesn't speak to particular things. And so to the extent that the law doesn't speak to the removability of these people, I thought our presumption was that we do have at-will removal.
Yes, the presumption is that there's at-will removal by whoever has appointment authority. And I think the question with Justice Gorsuch is, who is the person who has appointment authority? I don't think there's any serious dispute that whoever it is has at-will removal power.
And so do you think we need to get to the bottom of who it is?
Well, yeah,
in this case?
Either here or on remand, of course, if we need to be right that the secretary does have appointment authority to defeat their claim. We think that the secretary does have appointment authority. We think it's clear enough from the statute.
Who would it be if it isn't the secretary?
Well, in my view, the only other colorable reading of the statute is that it would be the director, because the statute says the director shall convene. But of course, that would render the statute unconstitutional, because the director is not the head of a department. And so that's yet another reason why you should read the statute the way we suggest, that when it says the director, under the backdrop of a statute that vests all powers to the director and the secretary has the power. My friend on the other side, his move is to say, no, it's the president who has the appointment authority confirmed by the Senate, invoking the backtrack principle that under the Appointments Clause, presidential appointment and Senate confirmation is the default rule for appointment. But the reason that doesn't work, as I was discussing earlier, is before the ACA, these were not officers. And if they were not officers, it would be unconstitutional for the Senate to have any role in their confirmation. So you cannot read the statute to have presidential appointment and Senate confirmation before the ACA, and nothing in the text of the statute changed after the ACA about who does the appointing.
I think you said earlier that at-will removal gives the secretary the power to influence the content of recommendations before they're made. Is that accurate?
I think that's correct, Your Honor.
And then, because that comes from the at-will removal power, correct?
Correct.
And how is that then square with the word independent?
Because it's still the task force ultimate judgment that matters. Yes, they can consider what the secretary wants. They may be even influenced by the fact that if they don't do what he wants, they might get removed. But it's still ultimately their call as a statutory matter. So I would point, for example, the benefits review.
It's an odd definition of independent, I suppose. Does independent in this context have any different meaning because the folks in question are not government employees, that they have outside affiliations, their employers, or wherever they're affiliated with?
Well, we do think that they are officers of the United States, so we do think they're government employees. But your point that they have other affiliations as well, we do think that's part of why
They're not paid, right?
Yes, they're volunteers, but we do think that that's part of the reason why it uses the phrase independent, to underscore that it's not just that they have the power to make the judgment based on their best scientific judgment, they have the duty.
But I hear you as not relying on the notion that independence in that provision means independent from, your university or your think tank or something like that. That you think that the word independent here does mean independent from political influences and particularly from presidential ones.
Well, in making the recommendation, we think that they have to exercise their best scientific judgment free from all of it. They shouldn't do what their university tells them to do. They shouldn't necessarily do what the secretary tells them to do. They should exercise their independent judgment based on the science.
But the secretary might say, and I think you acknowledge this, if you don't make the following recommendation, I'm going to fire you.
That's right. And so the analogy I would give you, Your Honor.
That's okay, right?
Yes. The analogy I would give you is the Benefits Review Board in the Department of Labor. So the Benefits Review Board in the Department of Labor is an adjudicatory body that is at-will removable. Because they adjudicate cases, they should adjudicate cases based on their view of the facts and the law. But it's true that if the secretary tells them, look, you come out one way, you're going to get fired, they might get fired, but they should still exercise their independent best judgment when they issue the ruling.
Well, what's this language to the extent practicable doing?
So, I think that it's not entirely clear, Your Honor, but I think that, if anything, it underscores our point that you should not read this statute, especially in light of constitutional avoidance, to say that the secretary can't exercise the types of review we've said.
I mean, it does suggest that Congress was thinking in some circumstances it would not be practicable.
Right. There's at least.
And what circumstances would Congress be thinking that about?
Well, at a bare minimum, the circumstances where the statute would be unconstitutional if the secretary couldn't engage in that level of supervision. So, I think that language just underscores the constitutional avoidance point that the limited forms of review that on the back end that we've emphasized have got to be permissible under that statute, both because it has that language in it and because the canon of constitutional avoidance says you should read it that way. And again, going back to the adjudicators, it's not just the Benefits Review Board. More generally, under the APA, the statutory scheme for adjudication has exactly this feature to it. You have adjudicators who are tasked with exercising independent judgment, but their actions on the back end can be reviewed.
Yeah, I understand the analogy to adjudicators, and I thought that's what was in your brief, but normally you wouldn't say with adjudicators that the supervising officer can influence the content of the adjudication.
Well, yes.
They can only review the adjudication after it's been made.
Well, but they also, as the Benefits Review Board says, you can also influence, you have at-will removal. And every one of these adjudicators knows
Right.
that they're acting under the shadow of that. So, does that affect them? Perhaps, but their duty and their power is still to make the decision based on their best judgment. Perhaps one way of making the point is.
And that's, so you're making the analogy, though, to adjudicators here, right? You think
Yeah.
that's a good analogy, and because their recommendations can be reviewed before they take effect, it's similar to all the adjudication cases where there's been supervisor review of the ultimate decision.
That's right. And one way of making the point is for these individuals, if the secretary tells them to do something and they don't do it, they do the opposite and make a different recommendation, that's not insubordinate, right? Because they have statutory power to make their independent best judgment. For most inferior officers, if the president or your head of your agency tells you to do X and you do Y, that is insubordinate. So that's what the language does. Now, that doesn't mean that you need to be protected from removal on the back end. You can be independent, make your own statutory judgments, but then have to face the consequences if the head of the agency disagrees with those.
Thank you, counsel. Justice Thomas, anything further?
Just briefly, what role did you say the Reorganization Act played with respect to the task force?
So several roles. The first is on the appointment question. We think that the Reorganization Act is a way that to confirm that the secretary has the direct appointment authority with respect to the task force members.
Now, is the task force, I thought the reorganization dealt with agencies within HHS.
That's correct, Your Honor.
Is the task force an agency?
We think the task force is within the AHRQ and within PHS, so it's within.
So what supports that?
Well, it is an entity that is convened by the Public Health Service, selected by the Public Health Service, supervised by the Public Health Service.
Is it structurally or statutorily designated a part of an agency?
Again, there's not anything that says they are or aren't, but I think the clear best reading of the statute is when you have an entity that's convened by the Public Health Service, selected by the Public Health Service, supervised by the Public Health Service, and supported by the Public Health Service, it's part of the Public Health Service.
Justice Alito?
No.
Justice Sotomayor?
There are any number, I think we mentioned them in our opinion, the opinion in Collins, that are deemed independent, but the president still has the power to remove the leadership, correct?
Correct.
I know that it seems to me that if the task force members are not paid, that means that they would take their oath more seriously, wouldn't it? Because they're not afraid of losing a government job.
Look, I'm not sure I would get psychoanalyze them that way.
No, but my colleagues are. They're saying that because they could be removed, they're going to automatically ignore their statutory duty.
Look, I think that they will exercise their statutory duty, and
which is to give a recommendation independently.
But I would say I wouldn't just say that means that the removal power isn't a means of supervision and influence.
Obviously, but I go back to the examples I've made, which is my law clerks I asked to give me their independent judgment of what an answer should be, and they'll tell you there's sometimes, a lot of times, I don't accept it. And I certainly have the power to fire them, and they still do it.
Correct, Your Honor.
All right. That's the nature of asking people to advise you, correct?
Yes.
Which some advice you will accept, some you won't. And you can choose to ignore your obligation, but that's not something we presume you'll do.
Correct.
Thank you.
Justice Kane? Justice Gorsuch?
So I understand that you agree that the government secretary cannot force a recommendation, but lean heavily on the fact the secretary can stop recommendations. I think your best authority for that may be Section 202. If I'm correct, you tell me if I'm wrong. And what in 202, if it is your best authority, gives the secretary that power?
So it's not quite, Your Honor. I the basis for the distinction is coming from 299B4A6. We think the statutory language says that they shall be independent in the recommendations made. And so we think that means that they get to make their recommendations, but that doesn't necessarily mean that those recommendations have to take effect.
Right, I
Now, the
understand.
statutory power
Yeah.
to block them, we agree, is both 202
Yeah.
and the Reorganization Act.
Okay, and focusing on 202 in particular, and putting aside the Reorganization Act for the moment, what in that empowers the Secretary to stop a recommendation from taking effect?
Well, so the Assistant Secretary for Health, who is supervised and directed by the Secretary, shall administer the entire public health service. And the ability to administer an agency is the language Congress generally uses to describe an agency head's power to control the whole agency. As we cited in the reply brief, that's the language that allows the Secretary of State to administer the entire State Department, is the Secretary of State shall administer. So we think that if it weren't for B4A6, there would be no question at all that the Assistant Secretary, and therefore the Secretary, could direct what the task force does, root and branch, from front to end. Because of B4A6, we acknowledge that the specific governs the general, and they have to be independent in making their recommendations. But that doesn't mean that they can't be blocked on the back end.
Thank you.
Justice Kavanaugh?
I might have misunderstood that, but I thought you were also relying on 300 GG 13B1 for the authority to reject a recommendation.
Well, that gives the authority to delay the effective date, but then you need some other source of authority to then make the recommendation go away.
So that's just the when, that's not the whether.
Correct.
Okay, thank you.
Justice Barrett?
I just want to clarify what you mean by the word independent or how you understand it. I mean, Mr. Mitchell is reading it in a very maximalist way. You are taking a middle road. I wonder, I mean, I was thinking of the law clerk example myself. Does independent even have to mean independent of the secretary? Because it seems to me that I could give my law clerk some advanced direction. I could say, I want you to make an independent judgment, and I want it to be free of political influence or free of outside influence. And by that, I would mean outside the court, I might mean outside of our chambers, but I might not mean for it to be apart from me, not independent of me. And I could even do that ex ante. I could say, give me your best understanding of this statute, which your best take on its interpretation, seen through the lens of, the way I interpret statutes, the way I see law. So not entirely independent. If you see statutes, I don't put a huge amount of stock in legislative history. So if I say, give me your best read on a statute and that's what they bring back, that's not going to be very useful to me. So they're not independent of me or my instruction, even though I could say they were independent in a very real sense of the word. But I take it that you don't adopt that view.
So, Your Honor, we could have taken an even narrower interpretation of independence along the lines you're suggesting. We thought the better reading of the statute in light of its context is the one we have articulated, where there is independence in the recommendation made, even vis-a-vis the secretary.
Even vis-a-vis the secretary.
But it doesn't block the secretary on the back end. Of course, if you want to interpret the statute even more narrowly than that, then that just makes it even harder for Mr.
Well, I
Mitchell.
mean, I think the fact that you could interpret it and I think give content to the word independence in an even narrower sense, I mean, you have a more middle of the road. And then, as I said, I think Mr. Mitchell has a really maximalist view. I mean, at a minimum, I think it shows that the maximalist view isn't necessary.
I think that's right, Your Honor. And again, ultimately, I think one way of thinking about this is an appointments clause challenge. So the question is whether there's adequate supervision. The court doesn't necessarily need to get into the exact level of what independent means and does it mean what you said or what I said. All the court really needs to say is there's enough supervision that these are properly understood as inferior officers. That's all you need to do to reject the claim here and reverse the decision below.
Thank you.
Justice Jackson?
And we also can rely on the constitutional avoidance canon. I mean, didn't you mentioned it a couple times, so let me just invite you to explain how that would work in terms of deciding who has the better reading of independence.
Sure, and so, we do think we have the better reading, but if you thought there was ambiguity here about what the scope of independence was or whether the appointment power was vested in the secretary rather than just the director, this court obviously reads statutes to avoid constitutional problems rather than create them. So you shouldn't read the phrase independent to impose a removal restriction that's not there, to impose a bar on review that's not there, to impose restrictions on who can appoint that aren't there. You should have read the statute to reinforce that the Secretary has adequate supervision so that the statute as written by Congress can continue to operate. And Mr. Mitchell's only real response to all of that is, again, to say, well, the statute is actually perfectly constitutional on even his theory because he thinks the president can appoint and the Senate can confirm. But that doesn't work as a statutory matter for the reasons we discussed. And once you take that off the table, his reading does create serious constitutional problems with the statute that you can void if you adopt our reading.
Thank you.
Thank you, counsel. Mr. Mitchell?
Mr. Chief Justice, and may it please the Court. The Court of Appeals correctly held that task force members are principal officers who must be appointed by the President and the Senate as required by Article 2. They cannot be inferior officers because their preventive care coverage mandates are neither directed nor supervised by the Secretary of Health and Human Services or by anyone else who has been appointed as a principal officer. The governing statutes make this clear. Section 300 GG-13A1 gives the task force alone the prerogative to impose preventive care coverage mandates on insurers, regardless of whether the Secretary approves or disapproves a task force recommendation. And Section 299B-4A1 and A6 require that task force members and their recommendations be kept independent and, to the extent practicable, protected from any type of political pressure. These statutes cannot coexist with a regime in which the Secretary can overrule the task force coverage recommendations or deny them binding effect. The Court also has no authority to sever Section 299B-4A6 as proposed by the government. The remedy prescribed by this Court must take the form of a final judgment to be entered by the District Court on remand, and a federal district court has no authority and no ability to formally revoke or cancel a statutory provision when entering judgment for a party. More importantly, a remedy from this Court must, to the maximum possible extent, respect the will of Congress as reflected in its enacted laws. Congress has chosen to create an independent task force and shield it from political pressure, and the plaintiff's proposed remedy honors that congressional decision. The government's proposed remedy would rewrite the statute into something unrecognizable by the Congress that enacted the ACA, and it is not even clear that Congress would have approved a regime in which politicians, rather than an independent task force, decide the preventive care that insurers must cover. I welcome the Court's questions.
Mr. Mitchell, your argument depends on a much broader reading of independent than the government's. Would you address the government's more limited view of independence?
Well, there are two different words in play here. It's not just the word independent, which appears in both Section 299B-4A1 and A6. It's also the phrase in subsection A6 that says the task force is to be protected from political pressure to the extent practicable. And we don't see any way that statutory language can be squared with the regime envisioned by the government, where the Secretary can come in and influence the task force decisions on the front end, which Mr. Mupon once again acknowledged in oral argument. He believes the Secretary can do that. And we don't see how that can be squared with the actual statutory language. Mr. Mupon suggests invoking the canon of constitutional avoidance in a way to bend subsection A6 to make it more accommodating of his view of secretarial power. But the constitutional avoidance canon is inapplicable here for many reasons. Number one, Mr. Mupon's proposed reading of subsection A6 does not avoid any of the constitutional problems that occurred. Under the government's interpretation of subsection A6, the task force members are still principal officers because they have unreviewable discretion when deciding not to recommend A or B ratings on a particular preventive care service, or when they decide to withdraw a previous A or B rating that they have conferred prior to their decision to withdraw. That means they have final decision-making authority that's not subject to direction and supervision. The second,
I'm sorry, I don't understand that. Can you help?
Yes.
What do you mean? They have unreviewable authority? First of all, I thought there was an interval period that the statute imposed.
That's right.
What function is that if not to have some consideration of what these recommendations are? That's one question.
Sure.
And then another is what do you mean about them having unreviewable discretion not to make a recommendation?
So the test for principal officer status is whether the officer in question is directed and supervised in his decision-making. On the government's reading of Section 299B-4A6, if the court were to adopt that view, the Secretary would have the ability to overrule task force decisions to confer A or B ratings on preventive care. But the Secretary would not have any authority to overrule the task
But
force.
why is that? Why is that? I mean, they make a recommendation and they have rejected other recommendation or other options. The Secretary puts into place the interval period, reviews what they did and didn't do, and says, I'm going to remove you. As a result, I don't like what you did or didn't do, and you're out.
That doesn't make them into inferior officers, and Arthrex holds as much, because Arthrex acknowledges situations in which a principal officer can, through informal means, influence the decision-making of a subordinate official. And Arthrex says that's still not good enough. There has to be a formal authority to review the decisions that are being made.
But what about all the adjudicatory cases? Mr. Mupon says this is more like Edmonds. This is independent in the sense that people are making recommendations using their own best judgment, but they're still at-will removable, and we found that is okay.
But they also have all their decisions subject to review by a principal officer. What this court said in Edmond was that the reason those judges were deemed inferior was because they could not issue any final decision on behalf of the United States without being allowed to do so by a principal officer.
Mr. Mitchell, I take that point, and the government concedes that a decision not to list something is unreviewable.
Yes.
But says that Free Enterprise Fund blessed that arrangement already. What are your thoughts?
The difference in Free Enterprise Fund was the SEC had all sorts of supervisory authority over the PCAOB, the Public Company Accounting Oversight Board, that is not present here. The SEC could review and alter any rulemaking done by the board. The SEC could review and overrule any sanction that was being imposed by the board.
And what about any non-action by the board?
Well, if you look at page 504 of the court's opinion in Free Enterprise Fund, it lists all the ways in which the SEC had these oversight authorities. And this is not, with all respect, Your Honor, this is not a situation of non-action. When the task force decides to issue a C, D, or I rating, rather than an A or B rating, that is action. It's not inaction. If the task force decides to withdraw an A or B rating that it previously conferred, that is also action and rather than inaction. So the government's brief tries to rely on the act-omission distinction. It just doesn't hold up here. There will be situations in which the task force can take affirmative actions that cause a certain type of preventive care not to receive the A or B rating, and the government concedes that's unreviewable. So that means they're still principal officers. But there's a second problem as well. Even if this court were to think that task force members become inferior officers under the government's interpretation of the statute, they are still unconstitutionally appointed because Congress has not vested the Secretary of Health and Human Service with the authority to appoint the task force. And the Court of Appeals did not reach this question, as Justice Gorsuch noted during the questioning of Mr. Mupon, but the court would have to conclude that there was vesting of this authority in the Secretary before it can say that they're constitutionally
So are you saying we
appointed now.
should remand to the Fifth Circuit to let them address that for the first time?
The court should not remand unless it disagrees with our principal officer argument, or if the court wants to impose the severance remedy suggested by the government.
So if we disagreed with your principal officer argument, you would say that you disagree with our principal officer argument, but then remand to the Fifth Circuit to give them a crack at the appointment.
I think there would have to be a remand in that situation, Justice Barrett, unless the court thought the issue was so open and shut.
Why do you think the Fifth Circuit didn't reach it? I saw that this was a huge part of the briefing before the Fifth Circuit.
It was.
It seems to me that it wasn't merely an assumption, it was a conclusion.
But
in their whole reasoning, the conclusion was...
Well, if I can defend the Court of Appeals for a moment, Justice
Yes.
Sotomayor, they did not need to reach that question because they concluded, number one, the task force members are principal officers. So there's no need to decide whether Congress vested the appointment authority in the Secretary. You only need to reach that question if you think they're inferior officers, because even inferior officers still need to be appointed by the President and the Senate unless Congress has affirmatively opted out of the default rule. But if you think they're principal officers, you don't need to reach that question at all. The second reason I think the Court of Appeals refused to rule on it was because they rejected the government's proposed severance remedy. And the court will also need to address this point if it wants to sever Section 299B-4A6, because the severance remedy proposed by the government is premised on the idea that the Secretary has constitutional authority vested by Congress to appoint the task force. If the Secretary doesn't have that power because Congress hasn't vested the power in the Secretary, then the government severance remedy does not work, because the inferior officers would still have to be appointed by the President and the Senate, even if they're considered inferior officers.
Thank you.
I guess I don't understand why you're separating the principal officers and the removability. I thought whether or not they are principal officers in part turns on whether or not they are removable at will. You seem to have separated them in a way that it's confusing to me. So can you help?
Well, we don't mean to separate the inquiry. Removability is a factor to consider. It's not the be-all and end-all of principal officer status, and this court has never held that.
I understand, but you said
you
the Fifth Circuit didn't have to really go into appointments or removability because they determined that they're principal officers. And I thought you can only reach the issue of whether or not they're principal officers by examining such things as how they are appointed and how they are removed.
The question Justice Sotomayor asked was, why didn't the Fifth Circuit rule on whether Congress had vested the Secretary of Health and Human Services with appointment authority over the task force? That was the question I was answering, and the Fifth Circuit had no need to reach that issue, and this court also has no need to reach this issue unless it disagrees with our argument on principal officers, or unless the court wants to impose the government's proposed
In the
severance.
reply brief,
No, please.
in the reply brief, the government came back with Hartwell. You want to address that case?
Yeah, Hartwell's not on point because in Hartwell, the statute required the Secretary of the Treasury to specifically approve the appointment of that inferior officer. So Hartwell concluded that was enough to vest the appointment power in the Secretary of the Treasury. We don't have anything like that in these statutes. Nothing in any of the statutes here requires the Secretary of Health and Human Services to affirmatively approve the appointment of task force members.
And I guess
Now,
the government comes back there and says, but they have broader authority the Secretary has broader authority to carry out the provisions, 299A and the Reorg Act. They say those together give the Secretary the authority to essentially stand in the shoes, I suppose, would be one way to characterize their argument of the director. You want to respond to
Sure.
that?
The Secretary is allowed to appoint the task force. We acknowledge that. Anyone is allowed to appoint the task force under the statute. The question is under the Constitution who can appoint. The statute doesn't say anything about who appoints, so anybody can appoint them. The AHRQ director appointed them for a
If you
time.
lose your principal, I think that's important. If you lose your principal officer argument, so that's the premise, not saying you will,
Right.
but if you do, and you just said, then you can read the statute to allow the Secretary to appoint, that's kind of the end of it.
No, I don't think so. That's not vesting. Right? Anyone can appoint under the statute. The Secretary of Energy could appoint. The President could appoint. The AHRQ director could appoint. Someone from the private sector could appoint. The statute doesn't say anything at all about who appoints. No one is vested with the authority because the statute takes no position on who appoints.
Yeah, so okay, and I think I understand your argument. Your argument is something's got to speak specifically to appointment. The general authorities in the Reorganization Act and 299 are not enough.
That's right.
And that's why Hartwell's different, because
That's
Hartwell,
right.
yeah.
We
I
have
got
a
it.
specific reference in the statute in Hartwell to the Secretary of the Treasury who must approve the appointment before it can take effect. We don't have anything remotely
Is your
like that
view
here.
that Congress actually wrote a statute without saying who should appoint?
Yes, because they didn't need the
Without
word.
even thinking that it was saying who should appoint?
Yes.
That Congress was leaving this just to the, whatever they come up with?
Yes, because this was initially established as a purely advisory body, so it didn't matter under the Constitution who appointed them. The Appointments Clause didn't apply to the task force when it was first created because it only had advisory
But even
powers.
if purely advisory, to pick up on Justice Kagan's point, it's unlikely that Congress just was throwing it out there in terms of who would.
I mean, usually Congress thinks that it does things like that, right? I mean, it would be an odd statute. I doubt you could find another where Congress has set up a board and said, just not said.
Well, all they said.
Who should make up the board?
All they said is that the AHRQ director shall convene the task force. And convene does not mean appoint, as Justice Thomas mentioned earlier.
No, but in the absence of anything else, it would be a natural reading to say, when you're looking at one person and saying he can convene the board, that means, and there's nobody else out there to actually pick the board members, that means he should also pick the board members.
He's certainly allowed to pick the board members, Justice Kagan. What we're saying is the statute doesn't forbid other people from appointing. The president could appoint the members of the task force. He could have done that prior to the ACA, and he can do it after the ACA. In fact, we think he's constitutionally compelled now after the ACA to appoint them with the advice and consent of the Senate. There is no statute that forbids the president
Well, if
to
convene
appoint.
does mean appoint, then we do have a problem on an inferior officer theory, don't we?
There is a problem, yes, because now we have a statute that's requiring the appointment of a principal officer by
even on the
someone who's
inferior-
not even a head of department.
Yeah, but even if you should lose that argument again, and we're talking about inferior officers, Mr. Mitchell, if we read convene to mean vesting the appointment power in the director, that's a problem.
That's a big problem. It means the statute is unconstitutional, and the court should therefore reject any interpretation of the word convene that makes it synonymous with the point, because that would create not simply a constitutional question, but a constitutional violation.
That's where you
Wait, why?
pull in 299A, which says the secretary shall carry out the statutory provisions acting through the director. I mean, that's their response to that. right?
Maybe that works. But again, the question Justice Gorsuch was asking me is, if A1 is construed to vest the appointment power in the AHRQ director, even the government would agree with
Yeah,
this. That's
that
unconstitutional.
alone would be a problem. I totally agree. But then maybe you have to figure out how to fix that problem. And one way that the government points out is, well, the statute itself essentially fixes that problem because it says that the secretary can carry out the duties of the director.
Maybe that works, but the question again under the Article 2 is, where has Congress vested the appointment power? And if Congress has vested it in the AHRQ director, who is not even a head of department, the AHRQ director can't even appoint inferior officers. And the government agrees with us on this much, right? One thing we all agree on is that the task force was unconstitutionally appointed for the 13-year period that began in March of 2010, when the Affordable Care Act was first enacted into law, through June of 2023, when Secretary Becerra reappointed the task force. Everyone agrees that those were unconstitutional appointments, and everyone agrees, I would think, that the recommendations that issued during that 13-year period cannot be enforced until the task force reissues those recommendations after receiving a constitutional appointment. So it's hard for me to understand why the government's suggesting a remedy of severance, when at the very least we should be entitled to an injunction that restrains the enforcement of those previously issued task force recommendations.
I don't want to belabor it, but I think to Justice Gorsuch's point, which is a good one, they're saying constitutional avoidance would say, well, don't read it to be the director in isolation. Read the other provisions which give the secretary authority over the director so that the secretary can do the convening/appointing, and that solves the constitutional problem.
Yeah, Justice Kavanaugh, I agree that the secretary is allowed to appoint the task force, and we've never disputed that.
And so it's
The question
vesting
is-
by law under Article 2. That's your key point there.
Right, vested by Congress. Where has Congress by law vested that authority? And if the statute is vesting the authority in the AHRQ director, that is unconstitutional, even if they're inferior officers. And that's why the court, I think, has to reject an interpretation of the word convene that equates it to appoint.
And you're saying, as well as I understand it, that if Congress didn't vest it in the director, but vested it in the director and the secretary and 15 other people in between, that's a problem too.
It's a problem too, because these are principal officers, so Congress
Even
can't.
if they're inferior officers, would it be a problem if if Congress vested the power to appoint an inferior officer in the secretary plus 15 people? Is that permissible?
I'm not sure. It would, at the very least, if they have vested it in the secretary, and they also go on to say in the statute, but other people can also exercise the power, it still has to be, I think, ultimately a head of department that exercises
But
power.
what if it's vesting it in the director subject to the supervision and control of the secretary? So there aren't 14 other people wandering around. It's in the director because he's the person who convenes, subject to the secretary because the statute otherwise gives the secretary supervisory control over the director.
I don't think that's good enough, Justice Kagan. I think the statute would have to say the secretary must affirmatively approve the assistant secretary or the director's recommendation. That was Hartwell.
But
If the statute went that far, I would agree. That's vested.
What if it
I don't think
says-
it's. I'm sorry.
Go ahead, Justice Kavanaugh. But doesn't that prove the point? There are all of these questions, and shouldn't we leave this to the Fifth
Yeah.
Circuit on remand if you lose the principal officer point?
Yes, I do believe that it should be remanded if the court thinks it necessary to reach this question. We don't think the court should reach this question, or any court should reach this
What
question,
if,
because
just to stay on this point,
Yes.
what if, Justice Kagan's point, what if it said secretary or director may appoint?
it says the secretary or director may appoint, then Congress has vested the appointment authority in a head of department. But we would still say that's unconstitutional because they're principal officers. So if the
Putting
court,
that aside.
if the court disagrees with us, if they reject our principal officer argument, that's the question that would have to be resolved by the Fifth Circuit on remand, Justice Kavanaugh.
I mean,
because-
it's a curious thing, just to continue to say, it's vested in two places. One is constitutional and the other is unconstitutional.
But at least Congress has made the vesting in a head of department.
Well,
And then I
but-
think the head of department would have to exercise that authority.
Well, what
for
if
this to
what if
work.
you didn't, though? What if the secretary didn't exercise that authority, but the other person did? I mean, we've never had a case like that.
I don't think
but-
there has, but I think the secretary would have to approve the appointment for it
Yeah,
to
no,
be valid under Hartwell.
Yeah,
And
so you're saying that under any circumstance, invested in 15 different places, but ultimately for it to be constitutional, it has to be the secretary who acts.
the secretary has to act
Sorry,
in some way.
You're,
And maybe
you're requiring, if I have an employee and they do something, and if I don't like it, I tell them, and if I like it, I leave it alone. You want the secretary to sign a piece of paper that says, the director took this action, I saw the task force, I saw the recommendations, I saw him leaving them in place, and that doesn't mean that the secretary agrees?
no, we don't think the secretary has the
You
authority
think
to
that the
do any of that.
Constitution requires him, giving Justice Kagan's example, that the director is subject to the supervision of the secretary?
Is Your Honor's question asking whether the secretary has to approve the task force's recommendations, or is Your Honor asking about whether the secretary has to approve an appointment to the task force?
Both,
All right, so
both.
if, this is a hypothetical I was being asked from Justice Gorsuch, if there's a statute that vests the appointment power in the secretary and another person, the secretary needs to sign off on the ultimate appointment if these are inferior officers. We reject that premise in order for the appointment to be constitutional.
All right.
Now,
I'm having a difficult time understanding.
Do you accept Hartwell? You just say this doesn't fall within
That's
Hartwell.
right. That's right. And again, all these issues probably should be remanded to the Fifth Circuit if the court thinks it necessary to reach this point. Because, number one, the Fifth Circuit didn't resolve the question below. There's very little briefing on this issue. We barely discussed this in our brief. There's a little bit of a more robust discussion in the Solicitor General's reply brief. But also,
2 pages.
yeah. This court has said, and this
I
court has
was
said many
agreeing with
times, we are a court of review, not of first view. So I don't think it would be prudent for the court to rule on that question in the first instance if it thinks it necessary to reach that. And of course, we believe it's not necessary for the court to reach that.
Can I ask you about your principal argument, the independence point?
Yes.
I mean, I guess one thing that I'm struggling with is, as I was suggesting to Mr. Mupan, your interpretation is very maximalist. And, normally, as Mr. Mupan said, we try to construe statutes to avoid constitutional questions, not create them.
Right.
And I feel like, there is a way, and during the colloquy with your friend on the other side, a lot of us were asking, ways that you can construe independence more narrowly. Why wouldn't we do that for the sake of constitutional avoidance? I mean, I assume you're going to say, oh, it's not plausible.
Well,
Is that the...
that's part of the answer. I mean, it's not just the word independence, but it's also the provision that says that the task force members have to be protected from political pressure to the extent practicable. So that is a maximalist interpretation that's in the statute itself. That language appears there. But I think, secondly, the
Well, I don't
statute
know.
is...
I mean, to the extent practicable actually seems non-maximalist to me. It suggests that there are limits, and we understand that sometimes it's not going to be possible.
It may not be possible. You can't censor people from talking, for example. And if you really wanted to make them completely immune from political pressure, you might have to sequester them the way jurors get sequestered during a trial and not allow them to read the newspaper or something to that effect. It's not saying that we should go to these types of extreme measures. But the reason I don't think constitutional avoidance is even relevant here, Justice Barrett, is because the statute is constitutional no matter how it's construed. Even if the court were to adopt our view of the meaning of independent, there is no constitutional problem with the statute. It does not violate the Constitution for Congress to give the task force authority to make these preventive care coverage decisions as long as the President and the Senate appoint them as principal officers.
I don't mean to interrupt.
Yes, please.
Just coming from a different Article 2 direction, we usually don't interpret statutes to create independent agencies without some indication that's stronger than what we have here, that this is really protected from presidential or someone else's secretary, head of department removal power.
I don't know how the language could be stronger, though, Justice Kavanaugh. It's not just the word independent, which is what we had in Collins against Yellen, and the court said that's not good enough to make it independent from presidential
Well, it could be
removal.
stronger if it had for-cause protection, and it could be stronger if it didn't have the phrase that Justice Kagan identified, to the extent practicable. Those are two big differences from what you would see normally with an independent agency. And normally with an independent agency, correct me if I'm wrong, the statutes usually say the president, by and with the consent of the Senate, shall appoint.
Right. And there's no
And that's usually in the statute.
It is, that's right, because it has to be in the statute. Otherwise,
And
there's
then
an appointments
says,
clause problem.
and many of them, although not all, say the for-cause removal protection too.
Right, but I think the reason we don't
Right,
have...
so all that's missing here.
That's true, but I think it's easy to explain why it's missing. This was initially established as a purely advisory body that had no real powers. So that's why they didn't initially say in the statute that the president has to appoint these people with the Senate's advice and consent. It was only when the Affordable Care Act, for the first time, gave the task force real powers as officers of the United States.
Can you speak
Well,
to the
point
year?
taken as to what the history is, but still, I mean, we don't go around just creating independent agencies. More often, we destroy independent agencies.
That seems to be...
You know, the idea that we would take a statute which doesn't set up an independent agency and declare it one strikes me as pretty inconsistent with everything that we've done in this area.
In terms of construing statutes to
In terms of-
maximize presidential influence over the...
Yeah,
over
I
the
mean, that,
independent
you know,
officials.
we've basically said we're not going to read something as putting restrictions on removal power unless it puts restrictions on removal power.
Right, but the problem here, it's not really a question of removal power, Justice Kagan. The test for principal officer status turns on whether the secretary can direct and supervise the decisions of these task force members. It's the question whether the
Well, why
principal-
isn't removal power enough? Suppose that there were clear at-will removal power here. I mean, we've gone to such lengths to say that that's pretty much, somebody said it's not the end-all and the be-all. I think Mr. Mupan said that. And I don't know if you read this court's decisions, it seems often to be the end-all and the be-all, that the court has suggested on many occasions that removal power is really the essence of control. If you have it, you have control. If you don't have it, you don't have control. Now, as you know, I'm sure, on a number of occasions, I've said that that understanding of removal power is not realistic, at least in certain contexts. But the court has said it again and again. So why doesn't it get you, if not 100% of the way there in a context like this, pretty near there?
I think that argument would have more force if it weren't for the opinion in Arthrex. And if we were litigating this case 10 years ago before the Arthrex opinion, I think that would have that would be a very powerful reason to say these could be inferior officers. But if you look at the Arthrex opinion, pages 15 and 16, where Arthrex catalogs all the ways in which the PTO director can influence the decision-making of these administrative patent judges in an informal way, without the formal ability to review their decisions. And then the court says, not only is that not good enough, it actually says that aggravates the problem. This is not the solution, it is the problem, because it blurs the lines of accountability and it undermines the transparency that the Appointments Clause is supposed to provide. Again, if Arthrex wasn't there, I think we could have an interesting discussion about whether the test for principal officer status should be this formalistic test that Arthrex sets forth, or whether we should have more of a hard-nosed legal realist look at the actual powers that the secretary can exert to influence the task force. But Arthrex really, I think, makes it hard for that argument to get off the ground.
Mr. Mitchell, can I ask you about the interval? Because we don't just have potential at-will removal power here. We have something in this statute that seems to me to be fairly unusual, which is the requirement that the secretary establish this minimal interval after the recommendation is made before it comes into effect. So can you speak to why that doesn't have some indicia of secretarial control that we can look to when we try to understand the relationship between the secretary and these members and their recommendations?
I think it has the opposite implication, Justice Jackson, because 300 GG-13 specifically addresses the secretary's role vis-a-vis the task force. And as Justice Kavanaugh suggested earlier, it only allows the secretary to determine when these preventive care coverage.
No, I understand, but it does so for a reason. I mean, if you're right that these are principal officers who are making binding recommendations, I guess I'm struggling to understand what the point of deferring them or allowing the secretary to intervene and defer them for at least a year. What is the point of that?
The point of that is it's very hard for insurers to change their coverage requirements in the middle of a plan year. So the minimum interval is set at 1 year. That's the minimum. So the insurance companies can plan ahead.
Congress could have done that by statute without the secretary being involved. They gave the secretary some authority to establish an interval. So the secretary is doing work.
Right.
Mr. Mupon says during that interval, the secretary can not only delay the recommendations, but can also, in his view, take some steps as to the constitution of the task force, perhaps even in communication with them regarding those steps having been done because they made certain recommendations with respect to which the secretary disagrees. So I guess I'm just trying, it doesn't necessarily suggest that really this is only a time-related thing. The secretary's getting involved, he's making decisions. Why doesn't that give us some basis for interpreting this to be a statute in which there is secretarial control?
But we dispute all of those claims Mr. Mupon made about what the secretary can do during that minimum time interval, because the statutes guarantee the task force's independence. What Mr. Mupon is describing, where the secretary can put pressure on the task force to pull down a previously issued A or B rating, is not consistent with the statutory guarantee.
But the statute doesn't have specific blocks, and so what I guess I'm going back to this notion of how should we be reading the statute? You dispute that the secretary can do all of those things, but the statute doesn't say he can't. And so why would we read the statute to prevent the secretary from exercising the control that is necessary to make it constitutional in this situation?
Because it doesn't make the statute constitutional for all sorts of reasons. May I answer, Mr. Chief Justice? It doesn't make the statute constitutional, Justice Jackson, because number one, there's still principal officers because they have unreviewable discretion when it comes to decisions not to impose an A or B rating. Number two, even if your Honor's proposed reading of the statute makes the task force members into inferior officers, Congress has not vested the secretary with appointment power over the task force, so they're still unconstitutionally appointed. And number three, your Honor's proposed reading of the statute still does not fix the problem that occurred from March of 2010 to June of 2023, when even the government acknowledges the task force was unconstitutionally appointed during that 13-year window of time, and all the preventive care coverage mandates that were issued during that time should not be enforceable until the task force members receive a new appointment that is constitutional and they reissue the A or B ratings in response to that constitutional appointment.
Thank you, Counsel. Justice Thomas? Justice Alito?
Would you comment on Mr. Mupon's argument that a distinction can be made under his understanding of what the secretary can do between pressure to get rid of a recommendation and pressure to adopt a recommendation in the first place?
Any kind of pressure, Justice Alito, is incompatible in our view with the statutory guarantees of independence. I don't see how that distinction can be reconciled with the text of a statute that not only guarantees the independence of the task force members and their recommendations, but also says that the task force and their recommendations has to be immunized from political pressure to the extent practicable. I just don't see how that distinction can be squared with anything in the text of the statute. I think what Mr. Mupon is trying to do is salvage some role for 299B-4A6. Because it's not plausible, I think even on the government's view, to allow the earlier enacted statutes such as Section 202 and the reorganization plan to completely swallow up these later enacted guarantees of independence. So they're trying to draw some line, but there's nothing in the text of the statute that can provide an anchor for the distinction that he's trying to draw.
Suppose it is ultimately decided that the statute implicitly confers the appointment power on the secretary, and that and then how much more of the statute would have to be jettisoned in order to make it constitutional?
I don't think
the
any
setup constitutional.
Yeah. None of the statute needs to be jettisoned in order to make it constitutional, even under our reading of the statute. If the court decides that Congress has vested the secretary with appointment power over the task force, the appointments are still unconstitutional in our view because they're principal officers. They have to be appointed by the president and the Senate no matter what. But if the court even rejects that view, there's still the problem that the task force was appointed by the AHRQ director for 13 years, between 2010 in March and June of 2023. And there has to be some remedy issued for those admitted constitutional violations.
So that would be for what was done before Secretary Becerra. What about going forward? What would need to be done?
Going forward, it will depend on whether the court thinks these are principal officers. If the court thinks they're principal officers, then they have to be appointed by the president and the Senate.
Suppose we thought that they were inferior officers.
If the court thinks they're inferior officers, there should be a remand in our view to the Fifth Circuit to rule on the question whether Congress has vested the Secretary of Health and Human Services with appointment power. I don't think it's appropriate for the court to decide that issue based on how cursory the briefing is.
Well, suppose suppose we do that. The Fifth Circuit goes back and says that, or we tackle the question and we say that the statute vests the appointment power in the Secretary. Then what?
Then there has to be some remedy.
That's what I'm asking.
The remedy
What
would have
the
to be
remedy
an injunction that restrains the Secretary from enforcing any of the task force coverage recommendations that issued between March of 2010 and June of 2023. Even the government concedes the task force was unconstitutionally appointed during that time. So I don't see how the government can deny that we're entitled to at least that much.
And what would be the remedy going forward if we went along that?
If the remedy going forward, if the court concludes that they're inferior officers and that the Secretary has been vested with appointment power, there should be no remedy going forward. We only can get a remedy for those past that 13-year window.
Thank you.
Sotomayor?
Can look this up later, but I thought that at a certain point, the Secretary had issued something saying that he was accepting.
He did, yes.
He did.
Yes.
So why
That's
do
on
we
page-
need a remedy if you're not questioning that he was entitled to do that?
Oh, we absolutely are questioning that he's entitled to do that.
For the
Fifth
same
Circuit-
grounds, but if we say that they're inferior officers, that
Right. So here's why that doesn't work. This is the ratification memo. It appears on pages 34 to 35A of the joint appendix. Fifth Circuit specifically held that Secretary Becerra had no authority to issue that ratification memo. That's on pages 27A,
is that
28A
because
of the petition.
why?
Because he has no authority to impose preventive care coverage mandates. Only the task force can do that. The government did not seek certiorari on that question. They have not asked, and they are not asking this court to reverse that part of the Fifth Circuit's ruling. So that is a closed issue. Even if it were
Then I'm
properly,
going to let the SG
All right.
answer that. Okay. thank
but even if it were properly before this court, that document is invalid because the Fifth Circuit's right. Secretary Becerra doesn't have the authority. But even if he did, that needs to go through notice and comment rulemaking because it's a substantive rule. It's a legislative rule that imposes binding obligations on private insurers, and it's implementing delegated authority that's been given to one of the agencies in the federal government. So it has to go through notice and comment under Section 553, and it didn't.
Mrs. Kagan?
It does seem, Mr. Mitchell, as though putting aside the vesting issue for now, that your argument really does rise and fall on how we read that independence language. And, just an alternative view of that language is something along the lines of, look, the members of this task force are going to be subject to some kinds of influence because somebody can remove them, and also because they're subject to supervision. But we want them to approach their jobs with a spirit of independentness.
All right.
And also, Congress is saying to the people who do supervise and who have discharge powers over them, you too should think about the fact that this system works best if the task force members are treated as independent. But it's hortatory. It's not saying that nobody can fire them. It's not saying that nobody can supervise them and nobody can prevent their recommendations from going forward. It's hortatory. So why shouldn't I read the statute that way?
Even if Your Honor reads the statute that way, there's still principal officers under Arthrex. Because under that view that Your Honor is describing of independence, there's no authority in the Secretary to formally review and formally reverse the decisions the task force is making in either direction. And that's what Arthrex says is key. There may be informal ways the Secretary can influence the task force, such as removal or threatened removal or other types of tactics. But Arthrex discusses all of these types of informal means of influence. Again, pages 15 and 16 of the opinion.
Okay, so
And it says
then I'm
that's not
going
good
to
enough.
say then your argument depends on a pretty aggressive read of Arthrex, because I thought Arthrex said we're dealing here with adjudicators, we're not dealing with every circumstance, every scenario. We're dealing here with a particular kind of officer.
I don't think that's an aggressive reading at all, because Arthrex says the touchstone for principal officer status is whether there is formal review available of the relevant official's decision-making. And even under the government's construction of the statutes, the only formal review that they're providing is formal review of an affirmative decision by the task force to issue an A or B rating. They admit that the Secretary can't reverse the task force if it makes a decision in the opposite direction, a decision not to impose an A or B rating. I mean, that alone is enough to make them principal officers, even under the SG's view, and even under Your Honor's proposed interpretation of the word independent. At the end of the day, when you go back to Section 300 GG-13A1, it is the task force recommendation that matters. That is what is binding on insurers. It is not the Secretary's decision that can bind insurers. So even if the Secretary were to say, I hereby disapprove this task force recommendation, that's useless when it comes to Section 300 GG-13A1, because what matters is what the task force says. It's not what the Secretary says.
Thank you.
Justice Gorsuch?
If I understood your exchange with Justice Sotomayor, and I just want to make sure I do, Mr. Mitchell, your view is if you should win either on the view that they're principal officers, or if we should remand on the basis that they're inferior officers who may not have been appointed by the Secretary, that the ratification of the Secretary of the task force past actions must fall. For a couple of reasons. One, he has no authority. I want you to spell that out a little further. And second, there was no notice and comment. And I understand that one. I wanted you to spell out the first one a little bit further. Make sure I've summarized it correctly, first of all.
And just to be clear, there's a third reason, which is that issue is not properly before this court.
That was my next question.
Right. I mean, it's not within the scope of the
I didn't
question
see that in this case.
Right.
So what do we do about
Well, I'm
it?
happy to answer Your Honor's question, but again, it's not properly before this court because it's not in the scope of the QP. The government did not seek certiorari on the question, and at no point anywhere in the briefing or in Mr. Mupon's oral presentation today has the government asked this court to reverse that part of the Fifth Circuit's ruling. But the ruling is nonetheless correct because the only entity that has the power to impose preventive care coverage mandates is the task force. The Secretary's role is only to determine when those coverage mandates take effect. So for the Secretary to go out and say, I hereby ratify the task force recommendations, that has no more legal force than if I were to produce a memo that says I ratify the task force recommendations. I don't have any authority to impose preventive care coverage mandates either, neither does the Secretary. So the document has no force. That's what the Fifth Circuit said in its opinion, and that's completely right. The other reason is notice and comment. The Fifth Circuit did not reach that issue, but this is undoubtedly a substantive rule. It's clearly a rule, and it's a substantive rule as well because it's imposing binding legal obligations on private insurers. It's prescribing law and policy, so it has to go through notice and comment unless some exception applies, maybe a good cause exception if the government wants to argue for that. But again, they've waived this entire issue, so I don't think they can possibly make that type of argument now about how an exception to notice and comment might kick in.
Justice Kavanaugh?
Your theory, I think, depends on us treating the task force as this massively important agency that operates with unreviewable authority to make really critical decisions that are going to affect the economy.
Yeah, it is.
And without any supervision or direction by the Secretary. And normally before that kind of thing would happen, Congress would have provided stronger indications that this task force is enormously important in the American economy and would have treated it as such. And I just don't see indications of that. And it's a big picture question related to my earlier question, but I just don't see the indicators that, oh, this task force, called a task force, is more powerful than the Secretary of HHS or the President in terms of how these recommendations are going to affect the healthcare industry.
No, it is more powerful than both of those individuals you mentioned.
Under your theory,
It's not my theory, Justice Kavanaugh. It's how the statute is written.
Well,
it says the task force shall be independent and shielded from political pressure to the extent practicable. It's hard for me to see stronger language than that if Congress is trying to
This
create...
goes back to the history. I mean, when that was originally drafted, that they weren't binding.
And I don't think Your Honor should be surprised that Congress would write the statute this way because it's perfectly consistent with this court's current doctrine. They are not exercising executive power. So Myers and all those lines of cases about how the president has to remove executive officers.
What are they exercising?
They're exercising quasi-legislative power. It's not quasi-judicial. They're not adjudicating anything. But they cannot enforce the law against anyone. They are making recommendations that have binding effect under another statute. That's quasi-legislative power, and it's a multi-member agency. It's not headed by a single director. So the holdings of Selah Law, Collins against Yellen, none of that applies here. This is perfectly constitutional under the court's current doctrine with respect to Article 2 in the vesting clause. Thank you.
Justice Barrett? Justice Jackson?
So I think your argument might be circular, and I'm sitting here trying to figure out how that is happening, and it's a little frustrating, but maybe you can help me to untangle it. It goes it starts with Justice Kagan's point, which is we're looking at the independence provision, and she says, okay, I'm not reading that as independent of supervision. I'm reading that as independent duty to make your own judgment.
Right.
Your response in your discussion with her was, well, even if that's the case, it doesn't matter because these folks are principal officers,
Right.
and you point to Arthrex.
Right.
And you say that the test in Arthrex is that there has to be formal review available, and we don't have that in the statute. Now, Mr.
Right.
Mupon says, well, we do have the provisions that make the secretary over this entire thing, and he says that counts. You say it doesn't.
Right.
To resolve that issue, who's right about whether there actually is formal review available? I took you to say the reason why you're right is because of the independence provision.
Well, it's more than just that. It's
No, but wait, this
Okay.
is important because
Please.
this is the circularity, right?
Right.
That if you come back and you say the reason why I'm right that there is not formal review under Arthrex is because we have an independence provision that has these people operating independent of the secretary or political pressure, then I'm back to Justice Kagan. But that's not what the independence provision means. So you both can't, I think, disclaim it on the front end, independence, it doesn't matter, Justice Kagan might be right, and then pick it up on the back end to say, but it's the independence provision that resolves the debate between you and Mr. Mupin over whether there's sufficient control by the secretary in this statute.
That's not our argument, Justice
Okay.
Jackson. We are not relying on the word independence to preclude secretarial review. We're relying on Section 300 GG-13A1, which says that it's the recommendations of the task force that must be given legal force and effect, not the recommendations of the secretary. So if we were to adopt Justice Kagan's proposed interpretation of the word independent, the task force will make its independent recommendations, but the secretary has no ability to veto them. He can try to veto them. He can issue a document saying, I, Secretary Kennedy,
But why do you say
disapprove,
he has no ability because of
Because-
the one provision? Because you read independent in one is saying, there's nothing in the statute that says the secretary can't veto. So where do you get that construct?
We get it from 300 GG-13A1 because the statute says that it's the A or B ratings of the task force that must be followed when determining what preventive care insurers must cover.
Okay.
It is not the recommendations of the secretary.
Thank you.
So, thank you, Your Honors.
Thank you, counsel. Rebuttal, Mr. Mupin?
So I'll pick up right there. So on the question of whether the secretary has the power to review, GG-13 just says that recommendations that are in effect are binding. It doesn't say one word about whether the secretary could prevent the recommendation from taking effect by directing the task force to withdraw it. His only argument on that is to rely on the language independent, interpreting independent way more broadly than necessary and creating constitutional problems rather than solving it. He recognizes that, and so he falls back on the point that even we agree that the secretary can't force the task force to make recommendations. But as Justice Gorsuch pointed out, that was already decided in Free Enterprise Fund. And my friend pointed out that in Free Enterprise Fund, the commission had lots of power over the PCAOB, which is true. But if you look at page 504 of Free Enterprise Fund, this is what the court said. The act nowhere gives the commission effective power to start, stop, or alter individual board investigations. That is exactly the argument he's making here, that because they didn't have that power, in this case, they're principal officers, and Free Enterprise Fund says even though they didn't have that power, they were inferior officers. Turning to the removal question, I didn't really hear any argument for why, as a statutory matter, you should read independent to create a removal restriction, even though that creates lots of constitutional problems. The best he did was to suggest, well, maybe it's just a question of timing, but actually the timing cuts against him too. B4A6, the provision that has the independence language, it was added to the statute with the ACA. At the time that Congress gave the task force these powers, that's when they added the language about independent and free from political pressure to the maximum extent possible. So if they wanted to impose a removal restriction, they would have done it using all the language that Justice Kagan and Justice Kavanaugh suggested. That's how they normally say impose removal restrictions. They wouldn't have just used the word independent. And Arthrex doesn't solve this problem either because, as the case makes clear, there was not at-will removal restriction power in Arthrex. In Arthrex, the APJs were only subject to removal for the efficiency of the service. They had cause protection. So Arthrex doesn't solve it for him either. Turning to the appointments question, I agree that it wasn't decided below and it could be remanded, but I think the colloquy here today makes clear why the answer is quite clear and why it'd be better to just resolve it now. My friend says that the statute is agnostic about who can appoint. I believe he even said that the Secretary of Energy or a private party could appoint these people. That is obviously wrong on its face. Among other things, it doesn't answer what happens if 3 different people all purport to appoint different people to the task force. You cannot possibly read the statute to say it's agnostic about who picks the members of the task force. And given that someone has to pick them, the word convene must suggest that the person doing the convening is the one who's doing the picking. So then, now all we have left is it the director or is it the secretary? And on that, we have 2 points. The first is that under the Reorg Act, all of the director's powers are the secretary's powers. The second point we have is, as Justice Kavanaugh pointed out, under 299, the secretary exercises all the powers of that agency through the director. So we think that that is pretty clear evidence that it is vested by law in the secretary. To use a hypothetical that came up earlier, if the statute just said it shall be appointed by either the director or the secretary, it would plainly be constitutional if the secretary was the one that did the appointing. We agree that if the director did it instead, and the secretary had nothing to do with it and didn't approve it on the back end or on the front end, that would be unconstitutional as applied. But there's no question that the statute would be permissible if it purported to vest the appointment authority in both the head of the department, permissibly, and someone else. And that's exactly what this statute does 2 different ways. And if there was any doubt about this, Hartwell, this is an easier case for us than Hartwell. In Hartwell, as you pointed out, there was an inferior officer who had the ability to make the appointment with the secretary's approval on the back end. But the decision in the first instance was vested in someone who wasn't the head of the department. And yet the court still said that that was enough to satisfy the appointments clause. Here, the secretary can, and in fact has, exercised the appointment authority in the first instance. So if Hartwell is okay, this is a fortiori from that. So for all those reasons, there's just no real good reason to remand this to the Fifth Circuit on this appointments question. There is no way you can read the statute to vest the appointment in anyone other than the director/secretary, and the secretary has complete control in that situation. Final point on remedy, we agree with Mr. Mitchell on this. If we are right that these are inferior officers, prospectively, he's not entitled to any remedy. And retrospectively, there will need to be a remand to figure out whether the old recommendations either have to be enjoined or can be ratified by the task force.
Thank you, counsel. The case is submitted.
The functional approach this court takes to notices of appeal. It was applied in First Tier, Lemke, and Luckenbach, and no one disputes, not the Fourth Circuit, not Mr. Houston, not any other court to my knowledge, that it's consistent with 2107A, which sets the notice of appeal requirement and the default deadline for filing. The Fourth Circuit was wrong to read subsection C as displacing the ripening principle and requiring a second notice in the reopening context only. The principle applies to notices filed after final judgment, just like it does to notices filed before. That's why courts have consistently held that notices of appeal ripen when an extension is granted under 2107C's first sentence. Nothing in the second sentence suggests that notices of appeal work differently for reopening, and requiring a duplicative notice of appeal would serve no conceivable purpose. I welcome the court's questions.
So you don't think that there's a material difference between filing a notice of appeal prematurely as opposed to too late?
I do think there's a difference, Justice Thomas. I think filing a notice of appeal too late, as this court held in Bowles, is a jurisdictional problem.
So why isn't this notice of appeal too late?
The notice of appeal is certainly too late with respect to the original appeal period. If nothing else had happened, there'd be no argument that the notice of appeal was timely. But there was another appeal period. The reopening was granted here, and it's too early with respect to that reopening period, in the same sense that a prejudgment notice of appeal is too early with respect to the original appeal period.
So I'm struggling with your argument. And the reason is because I'm not sure that ripening is really the best way to think about what is happening here. In my view, the notice of appeal was not actually premature. I mean, it was late with respect to the initial the initial period. But lateness doesn't necessarily doom your position, because in this context, we have a separate set of rules that allows for a late filed notice of appeal to be deemed timely if certain conditions are satisfied. And I guess what I keep coming back to in my mind is what happens in district courts every day when people file late, let's say it's a motion or a brief or whatever, and they have a motion for an extension of time attached to it. It comes in together, the motion for extension of time and the brief they want to file late. And when the court grants the motion, the clerk dockets the brief. There's not like an extra determination that the person needs to refile the brief or it needs to come in, it's there already because they submitted it along with. So in that situation, I guess I just don't understand. Nobody thinks of it as ripening. These things arrived at the same time, which is sort of what's happening here. The notice of appeal came in and it was construed as having a motion to reopen as a part of it, or construed as being a motion to reopen. So why do we even need ripening to get to the result that you are seeking in this case?
I think I agreed with just about everything you said, Justice Jackson. I don't know that there's anything to the concept of ripening as magic words. This court used that language in first year. It also talked about the notices of appeal relating forward. But I don't think there's anything magic about those words. I think the logic that you're articulating is similar to what this court said in Lemke, which is just that a premature notice of appeal is filed within the time.
But I guess what I'm saying, it's not premature. Like these things happened at the same time. The reason why ripening is confusing is because that is a scenario like the one that we talk about. Gosh, I don't have the name of the case right in front of me, but there are times when something will come in before the judgment, for example, and we have to wait for the judgment in order for the notice to take effect, and you say, okay, it ripens at the time that the judgment happens. Here, we don't have a separate action that we're waiting for this notice of appeal to be cognizable relative to. Do you understand what I'm saying?
I do. It was the same document.
It was the same document.
It was the same document.
It was the same document. So I can't understand why ripening is at play.
Is the concept. Yeah, I think it's not always the same document. You could file a notice of appeal and then realize you needed to file an extension motion or a motion to reopen. I think that happens too. You're certainly right that this often arises in the context of pro se litigants. It's often one document, but it doesn't have to be. If it's filed before a motion to reopen, at least before the motion to reopen is granted. I think another way to think about it is the prematurity is it's not with respect to the motion, it's with respect to the granting of the motion. So the motion is filed at the same time as the notice. That's absolutely right. But reopening isn't granted until after.
No, I understand, but for motions for extension of time for late filed documents, the same dynamic exists. The motion comes in stapled to the document, and the court has to grant the motion in order for the document to be deemed timely. I mean, what we're doing here is just deciding whether this notice of appeal should be deemed timely. And we have rules related to it. It's not timely with respect to the first set of rules, but it could be if the court finds the conditions related to motions for reopen exist, and they do. So, I just wonder why the Court of Appeals didn't just docket this when it came back to them, having had the district court find that the motion to reopen was, the conditions were granted.
I wonder that too, Justice Jackson. I think every other Court of Appeals would have. These are ordinarily just treated as notices of appeal that have become effective, in your language, have been deemed timely.
They're deemed timely as a result of the conditions.
I think that's exactly right.
You rely heavily on the background principle, and of course, amicus says, well, if that background principle controlled throughout, you wouldn't have 4A2 and 4A4, I think, in the rules, and therefore, there really is, that defeats the concept of a overriding background principle. You want to respond to that?
Sure. I think part of the confusion there is rules are a little bit different than statutes. Rulemakers sometimes just codify existing practice. Sometimes they just codify statutes almost exactly, or decisions by this court. Doesn't mean that the rules are superfluous or aren't doing anything. There's real value added. Even just by pulling them all together in one place, it's much easier to go look at the rules for appellate procedure than to try to search through all of the statutes for the relevant rules. So I think what the committee was doing was codifying common applications of this principle, both in the pre-judgment context. The rules just don't speak to this distinct context, which is notices of appeal filed after.
And is there any background as to why they codified those particular applications and not other applications? Do we know anything about that?
Sure. So Rule 4A2 was adopted at the same time as the old version of Rule 4A4, which displaced ripening for a short period of time. It said ripening actually doesn't apply in this post-judgment motion context. There were concerns that there might be confusion. Who has control of the case, the appellate court or the district court? So at the time the committee created an express exception to ripening, I think it made sense to make clear that it actually was preserving that concept in a closely related context. Rule 4A2 survived when the committee changed its mind. It said that hadn't actually worked very well, and it changed Rule 4A4 back in 1993. So I think that's a little bit of historical context. None of that had anything to do with this post-final judgment context, which doesn't have the kind of interlocutory appeal, final judgment issues that the committee was dealing with in the pre-judgment.
On that score, Mr. Houston suggests that background ripening principles were historically confined to the judgment context, A2, A4, but not to the reopening context. I wanted to give you a chance to address that.
Yeah, I don't think that's right. This court hasn't had a chance to address it in the post-judgment context, but there are cases going back to the 60s where it's been applied in the extension context, which works just like reopening. I don't have old reopening cases for you, Justice Gorsuch, just because reopening wasn't created until 1991. So we can't go back further than that. But extension, I think, is a pretty good analog. And those cases go back to the 60s. And I don't believe that there's any case that's rejected ripening in the extension context.
In that regard, you spoke about interpreting federal rules of procedure being different than interpreting statute. Rules themselves say that we have to consider efficiency and not to read the rules literally, but with the view to what's just, correct?
That's exactly right.
I was not taken, but you pointed out that in Scarborough versus Principe, in your reply brief, that we rejected the argument that background principle for pleadings codified in Rule 15C of the Federal Rules of Civil Procedure foreclosed application of background principles to other filings, like fee applications, correct?
That's exactly right.
And
I think
so that's in support of your argument that Congress usually with rules is paying attention to just one thing at a time.
I think that's exactly right, Justice Sotomayor. Scarborough is, I think, the best example. Chambers is another, where the court held that statutes and rules that address sanctions in certain contexts doesn't displace broader background authority that courts have to sanction litigants.
And we're not really even addressing the rules here, are we? Because as I understand it, the government has waived any objection under Rule 4A6. And it's a claims processing rule. So really the question turns on 2107 and the statutory limit.
Yep, I think that's exactly right. You don't have to say anything about the rules here if you don't want to, Justice Gorsuch. The Fourth Circuit ruled on jurisdictional grounds.
Maybe leave that to the Rules Committee. How about that?
You could. The rules just aren't jurisdictional as you held in Hamer, so it doesn't matter actually if you thought that the rules might require a second notice. And I think there's every indication that the Rules Committee might act on this. They formed a subcommittee to consider it.
I'm sorry, you took a step further than I had in my own thinking. So let me go back to that answer. If we answer it the way that Justice Gorsuch just suggested, we wouldn't reach the substantive question at all. We would just say, since it's a claim processing rule.
You still, I'm sorry.
No.
I don't want to answer your question. You can
Please. No, I expect what Justice Gorsuch was about to say is that you still need to answer the statutory question. If the statute requires a second notice in this context, as the Fourth Circuit held, then the Rules Committee is powerless to expand this court's jurisdiction. So all you need to hold is that the statute doesn't preclude ripening, and then the Rules Committee can act. I don't think the rules question's hard, so you could address it.
You did a better job with it than I would.
I mean, why wouldn't we answer the rules question as well?
I agree with that.
Save a little time, right?
Save everybody a little time. At least,
if you're correct on your interpretation, it seems like.
Yeah, I think it's a pretty straightforward question. I think it'd be helpful to say, as a as a default matter, the rules don't address this, and so it doesn't displace the common law principle. The Rules Committee could act to displace it if it wants to, but absent action from the Rules Committee, that's the principle that courts should apply.
Well, the rules don't address it, but in this instance, but they do in others. Others talk about relation forward, and this one doesn't. Shouldn't the expressio unius principle apply here?
I don't think so, Mr. Chief Justice. These rules codify common applications in a pre-judgment context. I think expressio unius recognizes when you're looking at specific enumerations, there's a context. So those rules address certain post-judgment motions and other pre-judgment issues. They don't speak to this separate post-judgment
I
context.
think the Chief's point, though, is relation forward is mentioned now in two other rules in Rule 4. In Rule 4. And doesn't that tell us something? I mean, maybe it's wrong. Maybe the Rules Committee wants to change its mind. Maybe it's irrelevant in this case since the government's waived it. But gosh, normally expressio unius means something in these kinds of contexts, doesn't it?
It means something. I think if there were another post-judgment motion, for example, that was not covered by Rule 4A4, you might read into that an intention by the committee to not cover that motion. But this is a different context. And expressio unius usually understands that the decision-making body or the person writing the statute or the rule is addressing the context at hand. And I just don't think that post-judgment notices are.
So we should look at A6 in a vacuum without looking at A2 and A4?
No, I think A2 and A4 are relevant, and they reflect the Rules Committee's recognition of this background principle. But the fact that there's no rule addressing 4A5, addressing extensions, doesn't mean that ripening doesn't operate in that context. The Rules Committee just hasn't codified that.
Thank you.
Thank you, Counsel. Justice Thomas? Justice Alito?
Do we have any information about the frequency with which situations addressed by 4A2 and 4A4 arise, and the frequency with which the situation present here arises?
I don't have any empirical data on that. My sense is that the 4A2 and 4A4 situation arises more frequently. That's part of what prompted the committee to address that issue and to make a rule. This issue, the reopening issue, didn't come to the committee's attention until recently because it doesn't arise very often, and every court had treated it the same way. I don't have any data to back that up, but that's my sense from looking at the cases.
Thank you.
Justice Sotomayor? Justice King? Justice Gorsuch, anything further? Justice Kavanaugh? Justice Jackson? Thank you, Counsel. Ms. Brown?
Thank you, Mr. Chief Justice, and may it please the court. Permitting a premature notice of appeal to ripen when the appeal period reopens is consistent with Section 2107, the rules of appellate procedure, and this court's precedent. Section 2107 doesn't address premature notices of appeal, but this court has already recognized that the statute doesn't preclude them. First here held that even though Section 2107 requires filing a notice of appeal after the entry of judgment, a notice filed before judgment relates forward to the day the judgment is entered. Rule 4 likewise confirms that premature notices of appeal can relate forward and require such treatment in multiple contexts. And this court's precedents have long instructed courts to disregard technical deficiencies in notices of appeal. Amicus's contrary position would require the court to hold that filing too early has the same jurisdictional consequences as filing too late, but that's flatly inconsistent with first tier, with Rule 4 and common sense. Unlike filing too late, filing too early doesn't disrupt finality or risk prejudice to others. Petitioners' premature filing provided adequate notice here, and there's no basis to require a duplicative filing. I welcome the court's questions.
Is there any difference between your argument and that of petitioners?
So not really, and not in any respect that should affect the outcome of the case today. I think petitioner's argument with respect to the way 4A2 and 4A4 are interpreted might be slightly different. We do take those two rules to be the only circumstances in which prejudgment notices of appeal can relate forward, or in which a notice of appeal filed while certain prejudgment motions are pending can relate forward. I think in some parts, at least, of the petitioner's reply brief, they suggested those rules may not cover the waterfront even in the circumstance circumstances that they address. We do take those rules to be codifying and displacing any inconsistent practices within those two contexts. But when the rules do not address the particular context, which is the case here, we think that that background judicial principle that promotes ripening or that preserves this kind of ripening in relation forward continues in effect.
You mean, so if there were another post-judgment motion that wasn't on this list, that's where you're distinguishing your position?
So I do take the petitioner this morning to have said, or my friend this morning to have said, that if there were another post-judgment motion, then maybe 4A4 wouldn't apply and ripening wouldn't apply.
Okay, and that's where you're distinguishing your position.
We agree with that, but
Okay.
I understood the reply brief, the petitioner's
Okay.
reply brief, to indicate that in certain contexts where there's a prejudgment, that there might be additional circumstances not covered by the rule where relation forward or ripening would still be permissible.
And Ms. Brown, what do you think about Justice Gorsuch's point that we don't need to address Rule 4 because the government has waived that we should just address the statute? Do you have a view?
So I do think that is correct, that this court could take a very narrow approach to this decision and just hold that Section 2107 does not itself preclude relation forward in this context, and that to the extent the rules might suggest that relation forward is not permissible here, those aren't jurisdictional. The government waived any argument about relation forward in this context or about the need for a duplicative notice of appeal, and therefore that waiver controls and could reverse. We do think it would be helpful for the court to recognize the existence of this background principle. It has been the rule that's been applied in 5 circuits. We don't see any issues with that. And of course, so long as the court holds that the statute doesn't preclude relation forward, the advisory committee can continue its work and can continue studying this issue and propose a rule that this court could then
What does
as
that
well.
do to Amicai's argument that it's a matter of discretion for the Fifth Circuit? That even though you waived it, that they could still say, we just won't accept the waiver?
So that's inconsistent with this court's precedent. In Wood versus Hilliard, the court has held that it would be an abuse of discretion for a court to disregard the government's waiver of any non-jurisdictional defense. And so we don't think that that is an available alternative argument for affirmance in this case.
But not addressing the rule question leaves open the possibility that in the future the government could refuse to waive.
That's correct, and we think that that would be another basis for the court to just ensure, to just clarify to the extent that there's any lack of clarity, although the other circuits have all held consistent with what we've said today, that relation forward here is permissible and is the correct result.
Is the background principle that
Exactly.
governs the interpretation of the rule. Okay, thank you.
Your differences, I just want to clarify on what you're saying. Other rules that don't expressly mention relation forward don't contain a relation forward element?
No, I apologize for the confusion.
No, I'm sure it's me.
What I was trying to clarify is that we do think that with respect to Rule 4A2 and the way that this court interpreted that rule in first tier, those are the only circumstances in which relation forward can apply for prejudgment notices of appeal. I take petitioner's reply brief to state that courts have continued to apply a broader kind of background interpretation or a broader background principle allowing relation forward even in contexts that wouldn't be directly covered by 4A2. And we think that Rule 4A2 does cover the waterfront, at least for prejudgment.
And can you give me an example of the differences?
Sure. So the court in, this comes, I think, or the opinion from the D.C. Circuit in Outlaw really kind of lays this out. Before the court adopted, before Rule 4A2 was adopted, there was a pre-existing line of precedents that had applied this background principle that had held that anytime there's a notice of appeal after kind of any decision, that would be permitted to relate forward to final judgment so long as final judgment had occurred before the Court of Appeals acted. And first tier limited that in some ways to suggest that the decision had to be one that would be appealable so long as judgment were entered right after that. And so we think that that narrower class of decisions is the class that's covered by Rule 4A2, and that the background principle is displaced as to the earlier precedents.
Do you think that the Rules Committee might have something profitable to say about how far this relation forward principle might obtain in 4A6 context too?
I certainly think that the Rules Advisory Committee will have the ability to study this issue and can take into account any comments that come from practitioners, or can look at the different contexts in which this arises, and may well choose to provide a more limited relation forward principle or to displace it altogether. But unless and until the Rules Committee acts, I do think that that background principle that provides for ripening should be applied.
They can't overrule what we do.
So long as the court doesn't say that it's compelled by the statute, I think that they actually can display. If you recognize this as a background principle, that doesn't mean that it's a background principle that can't be replaced by the rules themselves.
Yeah, fair enough.
Ms. Brown?
Thank you.
I guess I'm just really hung up on the characterization of this as a premature notice of appeal. And I totally see relation forward and all of that analysis in a situation in which the notice of appeal is filed before the judgment. The judgment has to be forthcoming in order for us to give any life to the notice of appeal. And so then you have a whole analysis as to what happens once the judgment occurs. Can you help me to see how that is analogous to what is happening here, where the motion to reopen and the notice of appeal are the same document? And I think it's filed late. The notice of appeal in this case is outside the window of when you're supposed to file a notice of appeal.
Right. So I think that the best way to understand this is that it's both too late and potentially too early. It's too late with respect to the appeal period that has, of course, already expired. But it's too early with respect to the potential reopened appeal period that might occur.
I understand that part is confusing to me because it came in at the same time.
The same time as the motion,
Yes.
but not at the same time that the motion is granted. And so once the motion is granted, the idea of relation forward is that we think of the date on which the motion was filed and the notice of appeal was filed, and we allow for it to relate forward.
No,
to the
I
date the
understand, but
motion
we
was
don't
granted.
do that with respect to other motions that are filed potentially too early relative to when they are granted. I mean, we don't do that. And so it's just a weird thing to suddenly say that even though this motion and the document to which it relates were filed at the same time, we're going to somehow give, life to the notion that you don't grant the motion until later, and so then we say the document has to catch up with that in some way.
So I think that this probably comes from the statutory text here, which states that the motion to reopen grants an appeal period for 14 days from the date on which the motion was granted.
I understand, but wouldn't the simplest, most straightforward way to deal with this is just to clarify in interpreting the statute in a situation like this one, in which the motion and the document arrive at the same time? That 14-day period is obviously satisfied. It's here.
I think that's consistent with what we're saying with respect to the relation forward principle. It may just be a different in kind of the terminology that you're using. The way I've thought about it is that any defect of prematurity in this area is effectively cured by the fact that you're just holding on to the premature notice of appeal until the motion to reopen is granted, and it's only given effect when that motion is granted. And so any defect that existed prior to that point disappears at that later date.
I guess they seize on the literal text, right?
Correct, right.
Time to file.
Right,
deal.
right, and we don't dispute that may be the circumstance that Congress had foreseen that may happen in these contexts, but now this rule is a rule that operates almost exclusively for pro se litigants and really almost exclusively for pro se prisoners who are filing by mail versus filing electronically. And for those litigants, I think it is a more common circumstance to be filing both of the documents at the same time. Sometimes, in fact, you have a litigant who does exactly, I think, what Justice Jackson was suggesting and files the motion to reopen, attaches a notice of appeal to that and says, please hold this notice of appeal and allow for it to be effective only if and when you grant the motion to reopen. We don't think that there's any problem with that kind of practice, but we also don't think there's a basis to distinguish that practice from a scenario where you have a litigant who just isn't sophisticated enough to specifically ask for that kind
What
of
do you say about the differences between 4A2 and 4, which expressly mention relation forward, and A6, which just doesn't?
So I take the same position on that as I think my friend did. I do think that when the Rules Advisory Committee and when the rulemakers were adopting Rule 4A2 and 4A4, they were doing so against the pre-existing backdrop of this ripening principle and of this relation forward principle. And they acted when they wanted to displace that in certain respects with respect to 4A4 specifically. And I think for 4A2, when they wanted to adopt, to codify some of those practices, but maybe not necessarily all of the practices. But where they're not acting, that we I think, read read that to mean that the pre-existing judicial practice remains in place. And I do think that's consistent with the Scarborough case that Justice Sotomayor was referencing
Even though
as well.
what about expressio unius?
So I take the expressio unius point, and I think that supports our reading of 4A2 to provide the exclusive opportunities for relation forward in the context that it's speaking to, which is the context of prejudgment notices of appeal. But this is not a prejudgment notice of appeal, and I don't take the rulemakers to have disrupted or displaced the pre-existing practice in that area.
And as you point out, A6 applies predominantly to prisoners and pro se litigants.
At this point, yes.
At this point. And the government waived compliance with A6
Yes.
in this case. And it's really only one circuit we're talking about where this is an issue. Is it the government's practice in that circuit to waive?
I'm not familiar with, this honestly doesn't come up that frequently even for us. I do think it's a very rare set of circumstances that has to occur in order for this to be the
Yeah, but is this a one-off waiver or is this the government's view?
I mean, I think, as far as I know, our position has been in this area that we don't think a duplicative notice of appeal is required. When we feel like we've got sufficient notice, we're happy to move forward with the merits of the appeal.
Thank you, counsel. Justice Thomas, anything further? Justice Alito? Justice Sotomayor?
The 4A language was necessary in part because the rule actually required a filing of the notice of appeal after judgment, correct?
That's correct.
And we don't have similar language here.
It's true that Section 2107C does not specifically require filing anything within that 14-day period. I think
Exactly.
I think it is implicit in that language that there will be a notice of appeal filed at some
Well,
point.
but I'm thinking of, which happens all the time, employment applications. I get notices all the time. You have X number of days to apply. The day after there's an announcement, there's been an extension. I don't think anybody reads that as requiring all the pre-deadline applications to be resubmitted, correct?
So I agree with that. I do think that there's a very common sense understanding here that something that comes in too early just shouldn't be treated the same way as something that comes in too late. You don't have the same concerns with disrupting finality or with prejudice to other parties.
Because what's being appealed is that judgment, and it's known what it is.
Correct.
Thank you.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh? Justice Barrett? Justice Jackson?
Thank you.
Thank you, counsel. Mr. Houston?
Mr. Chief Justice, and may it please the court. Section 2107C is unmistakably clear about what a litigant must do when he misses both the regular notice of appeal window and the time to request an extension. That would-be appellant must proceed in 2 steps. First, file a motion in the district court to reopen and demonstrate the relevant factors. And second, after entry of the order on that motion, file a notice of appeal within the next 14 days. The Solicitor General agrees in their reply brief that that process is the plain meaning of the statutory text. And that text does not permit petitioner here to be excused from the second step, filing the notice of appeal after the reopening window, just because he filed the wrong document at step 1. The lower courts exercised discretion to overlook petitioner's step 1 mistake, and they created a window for petitioner to file a timely notice of appeal. But petitioner did not take advantage of that reopened window, and he has never offered a justification for failing to do so. The Court of Appeals thus correctly determined that it lacked appellate jurisdiction because petitioner never filed a timely notice of appeal during any window when Congress authorized that notice to be filed. Any other conclusion would violate Rule 26b1's instruction that courts, quote, may not extend the time to file a notice of appeal except as specifically authorized by Rule 4. Now, Rule 4, as we've discussed, does contain 2 enumerated exceptions validating premature notices of appeal in certain limited circumstances. But as the court explained in first tier, those exceptions codify a much more limited practice than the one advocated certainly by petitioner. A reopening they codify a practice of excusing reasonable mistakes about when the notice of appeal should be filed. A reopening situation does not give rise to any similar reasonable doubt because the statutory text is incredibly clear about the process for filing notices of appeal here. The judgment of the Court of Appeals should be affirmed. I welcome the court's questions.
Would you comment briefly on the government's and petitioner's characterization of this as the notice of appeal being premature?
Yes, Justice Thomas. So I think I agree with my friend, Ms. Brown, from the Solicitor General's office, that the notice was both too late and too early. And again, I think that the statutory text sets up a process here, not the rule text. We're not relying on the rule. We're relying on the statutory text. The statutory text sets up a process of proceeding in 2 steps. It was, I think the notice was premature only in the sense that the petitioner filed the wrong document. He ignored the statutory instruction to file a motion to reopen and instead filed a notice of appeal. But I think that just reinforces the point that in order to file a notice of appeal, going all the way back to Curry in 1848, you must file the notice of appeal in accord with the statutory process. And here, the statute is very specific about when that notice of appeal must be filed. When? During the period after entry of the order on reopening, but before the next 14 days.
So to be clear, are you quibbling with the court's decision to construe the notice of appeal as a motion to reopen?
Not at all, Justice Jackson.
All right, so you say there are 2 steps, and he clearly, messed up on the first step. The court cured it by saying, we're going to treat this as a motion to reopen. I guess I don't understand why they also can't treat the second step as having been satisfied by the early filing of the document.
I think it's because of Bowles, Your Honor. Recall that in Bowles, the petitioner there filed a motion to reopen, but then ultimately filed the notice of appeal too late, after the 14-day period. And the court said it's a very harsh result, but the statutory text simply dictates the period when that notice of appeal must be filed.
I understand, but he didn't file a notice of appeal. In this case, he did, and it was the court that construed it as the threshold motion to reopen, and it just seems odd to me that having construed a document as a motion to reopen for the purpose of allowing for a document to be filed called a notice of appeal, when you have the document there, why couldn't the court also then say, okay, we have the notice of appeal within the window that we've just opened, and we're done?
Because there's no general practice. Your Honor, as you were describing in the colloquy with my friends, is exactly right, that with lots of different kinds of documents, courts do file this procedure. You make a motion to lodge an amicus brief and you attach the brief. Motion to file an amended complaint. But it doesn't happen with jurisdictionally significant documents like a notice.
The complaint is not a jurisdictionally significant document?
It has jurisdictional significance, obviously, in some respects.
No, I mean, let's explore this, because this is, I think, really the key to it, right? So suppose instead of filing a single document called the notice of appeal, Mr. Parrish had filed a notice of appeal, and stapled to the front of it was a motion to reopen. In that situation, if the district court had found that the criteria to open were satisfied, are you saying that Mr. Parrish would have had to send in a new notice of appeal?
As presently constituted, yes, because the rules are clear about that. But I think this is actually in the interest.
The one that the district court got to begin with would not be enough.
Yes.
Because it was filed too early.
Presently, because of the way that the rule text is written. But I think this is very important, and I think that perhaps the best thing that this court could do in this case would be to instruct the Rules Committee to adopt a new rule that would look very much like that one. I do think that's consistent with the statutory text, and the reason why is this court's decision in First Tier. First Tier explains that you cannot change the jurisdictional period when a notice of appeal must be filed. That's always jurisdictional. But importantly, the Rules Committee does have the power to enact rules that change how documents get filed. The best example is Rule 4C.
I guess what I don't understand is that if you can construe this very document as a motion to reopen for the purpose of all of the jurisdictional consequences that you're describing, I don't understand why you can't also construe that very document as a timely filed notice of appeal.
It's because, Your Honor, this court has said over and over again that the rule of liberal construction for pro se filers can accommodate looking at the substance of a document and understanding it to be something else. But importantly, the court cannot reconstrue when something is filed. That's the whole point of the court's holding in Bowles, is that there are limitations on the judicial discretion of construing something, and you can't just construe the thing to have been filed at a different time. So in a situation where the rules describe when the document must be filed for jurisdictional purposes, and 2107C is such an instruction, it must actually be filed during that period. But again, consider the prison mailbox rule. The prison mailbox rule, which we have no problem with, is a rule whereby the Rules Committee has provided an opportunity for certain filers to ensure that their filing gets made during the jurisdictional period. And I think actually importantly, Rule 4A2 also works this way. I would urge the court to take a look at the way in which Rule 4A2 is written. It's written awkwardly and very precisely. It says that the document will become, the notice of appeal will become effective on and after the entry of the judgment that authorizes the notice of appeal. It's written that way, I think, precisely because the purpose of the rule is to transport the filing into the jurisdictional period. And we think that is within the Rules Committee's power for the same reason why the prison mailbox rule is within the Rules Committee's power. But we don't have any rule like that as we sit here today. Perhaps the Rules Committee should enact one, and I think that as we've discussed this morning, there's every reason to think that the Rules Committee will carefully study this issue, and if the rule that my friends advocate is a good one, they may well adopt a rule very much like the one that Justice Jackson has suggested. File a motion to reopen and attach a notice of appeal, and then an instruction to the clerk to file that notice of appeal during the jurisdictional window. But the Rules Committee, with all respect, is much better suited than this court to undertake the process of developing those rules. This court, I mean, just acting by sort of one-off judicial decisions to deal with sympathetic litigants in individual situations. The committee undertakes, as the court is aware, a complicated process of study. Congress has the opportunity to weigh in. We're going to get a better overall rule if the Rules Committee is allowed to do its work.
Counsel, you make much of the expressio unius doctrine in your brief. You heard counsel's effort to distinguish that. Any comments on that?
Yes, Your Honor. So I think that Your Honor's opinion for the D.C. Circuit in outlaw is exactly right in two important respects.
I wasn't fishing for that, but you can.
Outlaw is important, most of all, because of what it had to say about this court's opinion in first tier. So as I think the Solicitor General helpfully explained here today, the reopening principle is not as broad as petitioner advocates, and I think it's really quite important that this court's decision in this case reject the sort of universal ripening principle whereby it's okay to file something too early. The reason that first tier is very clear about that. First tier says that yes, although there was at common law a certain ripening principle, it was never as broad as the one advocated by the petitioner. Instead, that ripening principle existed only to excuse reasonable mistakes about when a notice of appeal should be filed. And as I mentioned, because the statutory text is so clear, there's really no corresponding situation where a petitioner makes a reasonable mistake about when the notice of appeal is supposed to be filed. The Solicitor General agrees that our understanding of that statutory text is clearly the best one. So, and that is what I take to be the core thrust of the court's opinion in first tier, and this court's and Your Honor's opinion in outlaw recognize that. It said, precisely because first tier recognized that the principle, the common law principle, is more limited and has been codified in a more limited way, we, as judicial officers in individual cases, are not free to embrace a sort of universal ripening principle.
Well, if there is a ripening principle of some scope, some limited scope, what argument would there be that it should not encompass the situation here? What reason might there be for holding or concluding as a matter of policy, if this were sent back to the Rules Committee, that the principle should not apply in this situation?
So I think there are two, Your Honor. The first is that, and this is a situation that has actually played out in the real world in several of the cases that gave rise to this circuit split. You've seen two principal problems. False start appeals, number one, and second, sort of misunderstanding about court clerks, court administrative staff in the docketing and processing of the appeals. Both of them happened here. Both of them happened in the Winters case from the Sixth Circuit and the Holden case for the Third Circuit. So if you file a premature notice of appeal recall that it divests the district court of jurisdiction. The case will, in many cases, be transferred out of the district court immediately and into the Court of Appeals. But that's a mistake. Why? Because under the statute, it has to be the district court that decides the motion to reopen. So you get this sort of circuitous process where the Court of Appeals has to send it back, and then we have to put the appeal back on track. Now, I'm not trying to say that's an impossible problem to solve, but it should be discouraged. Petitioners should be discouraged from proceeding as this petitioner did.
But those are different situations from the situation in this case, right?
Well, that's what happened in this case, Your Honor, because the petitioner filed a notice of appeal instead of a motion to reopen. The case got sent to the Court of Appeals, and the Court of Appeals had to send it back.
Doesn't every other circuit, and that's everyone but this one, say that the sent-in early notice of appeal ripens upon reopening?
Yes.
So if it's a pretty straightforward rule, every other circuit has it, it's pretty clear when the process starts.
Well, but Your Honor, I think the problem is, again, in order to get to those decisions, a couple of the courts of appeals had to first sort of reroute the process that the statute lays out, where the district court decides the motion to reopen first. Courts of appeals had to grab the case, decide what to do with the mistaken filing, and
But they won't now.
Well, I think, but that only reinforces the point, I think, that the...
Well, it reinforces the point that you would like the Rules Committee
Yes.
to decide this and not us. But in the interim, what you're asking us to do is to make the rules unfair to pro se litigants who already didn't get timely notice to appeal because they didn't get notice within the 30 days, all right? And now they're supposed to get notice within 14, and given the way the post office is working, it's unlikely they're going to receive any notice in 14 days.
So, Justice Sotomayor,
Give it to the post office, give it to the prisons, but the likelihood of a prisoner receiving timely notice enough to file in time is next to nothing.
So if I might make 2 points in response to that. The first is, it's not me who's seeking to make the rule unfair. I'm here advocating that the court...
Yes, but you could advocate a reading that's totally consistent with background principles, not addressed directly by 4A. And so I know, we appointed you as a amicus.
But he was appointed to defend the judgment below.
Justice Sotomayor, I don't think
we've ever had an amicus come in and say, the judgment was wrong.
No, the judgment was not wrong. Certainly the judgment should be affirmed. But the principal reason why is the operative statutory text here in 2107C, as the Solicitor General agrees, does not allow what petitioner did here. So in order to get there, you have to say we're going to sort of excuse non-compliance with 2107C because we're going to incorporate this background principle. I think the fundamental problem with that is that the background principle is actually not nearly as broad as the one that petitioner needs in order to justify what happened here.
If you're right about what 2107 means, doesn't that mean that the Rules Committee is going beyond what the statute says, even with respect to the provisions in Rule 4 now, let alone to any that they might issue with respect to this situation?
The answer is no, Your Honor. We think Rule 4A2 is faithful to the statutory text, and it's because the Rules Committee has been careful to write the rule in a way that respects the jurisdictional nature of 2107A. And again, that just gets back to that text and the way that that rule is written. First Tier discusses this. I mean, the argument presented to the court in First Tier was Rule 4A2 exceeds the jurisdiction. The Rule 4A2 is improper because it goes beyond what the statutory jurisdiction conferred by 2107A. The court said, no, it doesn't do that because it's not a rule that changes the time in which the document must be filed. That's the jurisdictional period. Instead, it's a rule, 4A2 is a rule about how that document gets filed, akin to, again, the prison mailbox rule that enables, decides when and how something is being...
So I think I'm not understanding. Are you saying that the Rules Committee could or could not issue a rule that's similar to the one that the petitioner asks us to reach?
I think that the committee could enact a rule that is similar, but it has...
Consistent with 2107.
Consistent with 2107 and consistent with its text, so long as that rule is crafted in a way that respects the jurisdictional period. So
Well, I don't understand. What does that mean? What could the Rules Committee do that we can't do right now?
So I think the Rules Committee could enact a rule that would say that you can file a motion for reopening in the district court, which is clearly what 2107C instructs. And then you can attach to that a conditional notice of appeal or a proposed notice of appeal. And the court clerk, the Rules Committee would direct the court clerk to file that notice of appeal within the jurisdictional window. That's going to solve the problems of this case and all of the ones that gave rise to the circuit split. But that's not a principle that we have in the law, in the rules at present for jurisdictional filings that divest the Court of Appeals of jurisdiction. We typically don't allow notices of appeal to sort of lie in wait. Maybe it would be a good idea to authorize this filing in this circumstance for partly the reasons that Justice Sotomayor describes. But I think that's a thing that the Rules Committee needs to do. And the important reason why it's not just better as a policy matter for the Rules Committee to undertake that, but why I think it's actually compelled to be the Rules Committee that does it, is that remember that when we're talking about a rule, we're talking about something that's been authorized by another act of Congress, the Rules Enabling Act. So you have two different sources of authority. You've got a jurisdictional limitation set out in 2107A, but you've also got an authority from Congress to make rules to implement that. That doesn't happen in a situation where the court is just hearing individual cases.
Maybe I'm looking at the wrong statute, but 2107 doesn't say anything about what the defendant has to do. Isn't it only speaking to the district court? The district court may extend the time for appeal. The district court may reopen the time for appeal for a period of 14 days from the date of entry or the order reopening the time for appeal.
Yes, of course, Your Honor, that's right. The district court has to reopen the time for appeal. For
a period of 14 days.
Precisely.
So what about that precludes the district court from considering a notice of appeal that has been filed as timely within that 14 days?
I think it's because, as the Solicitor General agrees, 2107C, the provision that you were just reading, incorporates the general principle of 2107A, that an appeal within the time for appeal, that's the statutory text of 2107C, an appeal must always be taken by the the appellant filing a notice of appeal. That's 2107A. That's, of course, the general way that that's the only way that notices of appeal that appeals can ever be taken under 2107A is that the appellant must file a notice of appeal. And then 2107C describes when that notice of appeal has to be filed within a period of 14 days that has both an end point and a beginning point. It runs from entry of the order on the motion for reopening. No other provisions of 2107 are written in this specific way, and I think the specificity that Congress used to reference the period of 14 days is among the strongest evidence that Congress, when it thought of this particular situation, was intentionally reaching a balance. Yes, Congress wanted to create an opportunity for a litigant who did not receive notice of the judgment to file a notice of appeal. But it only created a very limited and particular window in which to do that. And that's because, obviously, the judgment prevailing party's interests in the finality of that judgment go stronger and stronger as we move further and further away from entry of the judgment. So,
well, isn't that the reason for a 14-day limit, and so it can't be filed months later, obviously, but if something's already been filed or filed within the 14 days, that concern that you just raised, I don't think is present.
I think it's the reason for both of the 14-day periods that are referenced in 2107C, Your Honor. I think clearly Congress was attempting to strike a balance, and it was attempting to be quite demanding on a situation like the one facing petitioner about what you must do when you get notice and when you must do it. And Bowles is the surest proof of that. Obviously the court is saying in Bowles that if you fail to scrupulously apply or comply with the 14-day deadline, even in arguably like the most sympathetic circumstance that I can think of, the court, are going to enforce that jurisdictional term. I think our point is just simply that the jurisdictional nature of this statute runs both at its end point and at its beginning point because of the particular text that Congress used in this provision.
Counsel, your argument throughout most of your brief sort of puts emphasis on turning square quarters in this area because it's jurisdictional. And then on page 42, you said, well, if you don't like that, we'll leave it up to the discretion of the district court. You want to say a little bit more about the discretionary approach?
Your Honor, I mean, this is an argument in the alternative. Our point, we think, we absolutely contend that just as in Bowles, there's a jurisdictional period that Congress created, and by default, there is no judicial discretion to sort of forgive it in individual cases. If the court rejected that, I do think that in order for petitioner to win the case, they need an exercise, they need a deeming of one thing to happen at a different time. And I think that is very much an argument that sounds to me in judicial discretion. So petitioner needs to go to the Court of Appeals or the district court, as the case may be, and say, please take my document that was untimely and deem it to have been filed at another time. They analogize it to the common law nunc pro tunc authority, but that was always an equitable authority. And I think our point is just simply that on the particular facts here, where the Court of Appeals said, not only did you fail to file the statutory text and the rule text, you also disregarded the specific instructions that were given by the district court to file a notice of appeal. On that basis, we're not going to allow your notice of appeal to ripen. I think that would be a reasonable and not an abuse of the Court of Appeals discretion on the particular facts here if the court concluded that the deeming authority is available at all, in which case, again, I think it's something that sounds in judicial discretion.
Justice Thomas? No? Anything further? Thank you, counsel.
Thank you, Your Honor.
Rebuttal, Ms. Rice?
There's been quite a bit of focus today on the rules for understandable reasons. I think the rules question is straightforward and this court should answer it. The rules don't speak to ripening in the post-judgment context, and so they don't display settled practice in that area. But the main question before this court is about the statute. The Fourth Circuit read the statute to impose a jurisdictional second notice requirement. I take my friend's statutory two-step to be functionally the same thing. That's wrong. Nothing in the text of subsection C displaces the background rule. We usually construe statutes to incorporate background rules unless they say otherwise. We also usually construe provisions that operate across multiple subsections to work the same way. I think that's true of subsection A here, the notice of appeal requirement. We also don't usually construe statutes to defeat their purpose. This was about creating a mechanism for litigants who don't get notices of judgments to reopen their time for appeal. It was not about setting a trap for the unwary. So we're not excusing compliance with a jurisdictional requirement here. There just is no jurisdictional requirement to begin with. Were it otherwise, I think first tier was wrong, and rules 4A2 and 4A4 have to be invalid. My friend's concession that the Rules Committee could enact a ripening rule for this context, I think effectively acknowledges as much. I don't see how the Rules Committee could do that if the statute jurisdictionally required a second notice here. There are no further questions.
Thank you, counsel. Mr. Houston, this court appointed you to brief and argue this case as an amicus curiae in support of the judgment below. You have ably discharged that responsibility, for which we are grateful. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.